Hello. How are you? Is your mic on? Oh, thank you so much.
Must it be on red? Good morning, Deputy Chief Justice. I'm fine, thank you. How are you?
I'm fine, thanks.
And good morning, Commissioners. I'm sure all of you are happy that it's Friday.
Right. You have applied for a vacancy in the KZN division,
Yes, DCJ.
and not for the first time. Am I wrong?
That's correct.
Is this your second time here?
It's my second time.
All right. You are an alumnus of the former University of Durban Westville,
Yes, DCJ.
where you obtained a BA and an LLB.
Yes.
Right. So after you got your LLB, according to your CV, you went straight to the sidebar to do your articles,
Yes, that is so,
and
DCJ.
you started practicing as an attorney
Yes.
to date.
Well, there has been a break in my private practice. I served articles as soon as I completed my degrees, and then I started a private practice, which I ran until 1996. I then sold that practice and joined the Industrial Court bench, where I was from 1995 to the year 2000. I then joined the CCMA as a commissioner, arbitrator, and that's where I am currently.
All right.
During 2015, my two children, who are also attorneys, started a private practice, and I joined them there as a partner. But as I indicated on the last occasion during my interview, that I haven't been litigating, haven't been a litigating lawyer in that time.
All right. What kind of work does your practice do?
It's specializes in labor law, but in the time between the last interview and this interview, I've taken the time to acquaint myself with the work that is done in our office, and it's civil litigation and commercial work relating to FIDIC, for example, commercial leases, and insurance litigation.
All right. You have acted as a judge in the KZN division intermittently since 2017.
That is so, DCJ.
And you acted at the labor courts as well.
As well, yes.
Between 2021 and last year?
I beg your pardon, DCJ?
Was that between 2021 and last year?
It was in the latter half of 2021.
Just that half, the 2 terms?
I did 10 weeks at the labor court, out of which 1 week was pro bono, yes, at the second half of 2021.
All right, and what is the total period of time you've spent at the High Court?
I think it would be about 60 weeks, if I'm not mistaken, or just maybe...
60?
Might be 50 weeks.
Sorry?
I think it's 50 weeks, DCJ, and then I add...
50 or 15?
50.
Oh, okay, 50.
Yeah, plus 10 weeks in the labor court, which would make it 60.
All right.
I believe that might be the approximate number of weeks.
Okay. Did you sit in both the civil and criminal courts in the High Court?
Yes, I did, DCJ.
All right. In all the courts, you went through the whole gamut, agent court, motions.
Yes, I've done
appeals.
the whole spectrum of cases in Pietermaritzburg as well as Durban, motion court, civil trials, criminal trials, reviews, appeals, civil appeals, and criminal appeals, as well as full bench and full court appeals. I always get confused about that, which is full bench and full court, but 2 judges and 3 judges, also where I have scribed the full bench judgments as well in civil court, civil appeals.
All right. Your application indicates that you have no experience in constitutional law. constitutional and administrative law. Now, if you've gone through the whole spectrum of cases, how could you have avoided coming across constitutional and administrative law issues?
I've not practiced, but I understood you to, the questionnaire to ask about my litigating in constitutional
Or
law.
in your practice?
Yes,
Mm,
but
all right.
as an acting judge, I have come across constitutional principles, and I've had to deal with cases where I've had to consider pacta sunt servanda, the rights of children to education, etc.
All right. You don't have any reserved judgments according to your application form,
Not at the moment.
but you did list 2 trials, 1 criminal and 1 civil, that was still pending?
No, they're all completed, these.
They've been finalized?
Yes.
All right. Did you manage to write any judgments during your acting stints in both the High Court and the Labour Court?
Yes, DCJ. In the High Court, I've written about 40 judgments. In the Labour Court, I wrote 30 judgments over that 10-week period. That's
30?
30 in the 10-week period. That's apart from the urgents and the extemporaries
Yeah, that's quite an output.
in a 10-week period.
Any of them taken on appeal?
There is one currently pending appeal in the High Court. I understand the judgment should be handed down soon. There were a few leaves to appeal in the Labour Court. I don't know what the status of those appeals would be. But in the CCMA, I've written hundreds of awards, and I've not been set aside at any point. In fact, some of my awards have been upheld by the Labour Court and the Labour Appeal Court.
Mm-hmm. You would be aware of the concern raised by AFT, the Advocates for Transformation in KZN, who say you are better suited for the Labour Court, and they complain that you struggle in the High Court. They specify your experience in the motion court, which they say you are not able to manage, you get overwhelmed, they say. And they also complain that your turnaround time to deliver judgments is poor, and that parties have had to wait for extended periods of time for judgments from you. Would you like to comment on?
Perhaps I'll address the last one first, DCJ. I understand that they say that there was a leave to appeal that some time was taken to deal with that or to hand down a judgment there. I've had very few applications for leave to appeal, and I've not delayed any of them. On the contrary, in crime, I received 2 applications for leave to appeal, and I did extempore judgments there. In the civil court, it would have been a period of a week or maybe slightly more than that where I handed down judgments in applications for leave to appeal. So I understand that that is an incorrect or inaccurate statement about handing down a leave to appeal judgment. That's what is being referred to from what I understand. They haven't complained about my other judgments.
No, they say that this statement is too pronged. They say your turnaround time for delivery of judgments, they speak of judgments is poor, and then they give this.
I'm sorry, DCJ, can I just have a look at that?
It's in book 1 of 1. Unfortunately,
it's
this
for
book is not
AFT.
paginated. It's page 3 of the comments under your name.
I've got
Comments
Professor
from the-
Matenjwa's AFT. Sorry, which paragraph?
It's paragraph 6 at page 3 of the comment from the Advocates for Transformation.
Oh, I see. I concentrated on the second part of that because there
Oh.
was no delay in the any leave to appeal judgment. My turnaround time in the High Court, DCJ, is normal. It can be anything between a week and under 3 months in the High Court. So I don't understand where that would come from. If they were referring to Labour Court, where I've addressed that on the last interview, then I would understand. But it's not happened in the High Court.
Okay. Well, there's this other concern they express about how you have handled motion court.
Oh, yes. DCJ, that is surprising to me because I have, this year, I would be in the legal field for 39 years. I've got about 28 years of adjudication experience. I've dealt with complex matters in the CCMA, in the Labour Court, in the High Court. When I came to the High Court, I had no difficulty dealing with the courtroom atmosphere, and I embraced dealing with motion court. I'm not intimidated in any way or any form by the courtroom, the procedures, the counsel who appear before me. So I don't understand how it can be said that I'm overwhelmed. I don't know the paragraph as well, where I recall it says that I don't prepare for motion court well enough, and then I'm overwhelmed by the workload in motion court. That does not happen. When I started to act for the very first time, I was assisted by one of the judges in the High Court who showed me how to deal with the motion court role. She took me through my motion court role, showed me how to work the bench book, all of that. I believe that the 48 hours that we have to prepare for motion court is more than adequate. I am able to go through my files twice over before I walk into motion court. So I don't have a difficulty with motion court at all, whether it's the quality of the work, the quantity of the work, or the people who appear before me, DCJ.
No, thank you very much, Ms. Hirala. Am I pronouncing your name correctly?
Yes, thank you, DCJ.
I'll hand over to the rest of the commissioners to put their questions to you. And JP Boyotlwati,
Thank you.
to whose court you are applying, will have first bite.
Thank you, TCJ. Good morning, Ms. Hirala.
Good morning, JP.
We know each other because when you first started to act, I probably was in the High Court as a puisne judge then.
That's true.
Yes. Now, I just want to check in your page 17 of the application form about the acting stints, the last two. Which courts were you in and what were you dealing with there?
My last two acting stints were in Durban,
Yes.
in civil court. I was in both times. I was in civil court.
Okay. So just following up on what the DCJ has asked about the comment from AFT. Obviously, I've been the JP since January, but you have not acted where I was the senior judge in the court. So I'm not able to assist this commission about what my gauge was about your performance in the High Court. But I did take that into account and checked with some of the senior judges that were there when you acted. And they seem to support that you did seem overwhelmed at certain times, as particularly in Durban. So I don't know what your view is about that.
Overwhelmed in relation to
the workload, particularly in the motion court.
I'm not sure which judge would have said that. I believe that there was a weekend, the 21st of March weekend, where there was I was dealing with motion court, and it was the start of the long weekend. The Monday was, all cases for the Monday were cancelled. And so I was dealing with motion court, and I had 2 opposed motions on that day, as well as during the course of the morning, I received 2 urgents, which I read during the tea break and prepared myself for. I paced myself well because the representatives for the opposed were already sitting in court early in the morning, and I told them to come back at 2 o'clock, so we'll deal with that. But just before the lunch break, I received another urgent. So in that time, I received 3 urgents. So I may have spoken to a judge about the fact that there's one more urgent, and it's the beginning of the long weekend, and the court staff might be wanting to go away. But then I handled that as well, and ensured with the court staff that if they had to leave by 4 o'clock, at least there would be someone to be recording with those opposed motions that I still had. So that was the position there. But other than that, JP, I don't recall complaining to anybody about workload.
How did you find the workload, particularly in the Durban High Court? Because that's the busiest division.
It is the busiest division. But JP, if I can compare it to the Labour Court, the High Court, and what I have said many times, is that the Labour Court is far busier. And in the Labour Court, I would do anything between 15 and 25 cases per week. That is 2 to 3 reviews, as well as my own motion role. And I handled that. So the Durban court role is not so busy compared to, it is busy, but it's not as busy as it was in the Labour Court. We have time to prepare for our motion court. We're not given trials the day before the motion court. I've not had that experience, but if that happened as well, I would deal with it. I've not had a difficulty, JP.
Yes. Now, the previous interviews I've had regard to that, to the record, and most of the commissioners here and some of the comments refer to the fact that you are better suited in the Labour Court, but you have not accepted that.
That's a good point, JP. I was given the opportunity to act in the High Court first, and I embraced that. I love it. I've worked there with a passion, joy and passion for the work that I've been given the opportunity to do. My last experience with the Labour Court was not so easy, where I picked up 30 reserved, I wrote 30, I delivered 30 written judgments in that short period of time. And I understand that that wasn't a good reflection on my performance. And I'd like to compare that to my CCMA performance, where the most complex matters, as a senior commissioner, which I am, the most complex awards are handed down within a 10-day period. No exceptions. If there's an extension, it's only a 7-day extension, which is not much. So the Labour Court, it pained me that I had this blot on my reputation, that I had 30 reserved judgments, and then I had to write these down. By the time I came here at the last interview, I had only 3 left. I don't find that the workload is too high, that it's too much for me to deal with. I've dealt with this kind of work for many, many years, and I would be able to deal with it.
Yes. Now, just going to the booklet that you have submitted, I was overwhelmed by the amount of judgments that you submitted. I didn't know whether you wanted to make the point that you know, because as I recall, you are required to submit 3 or 4. You can choose, but you have submitted more than 4. But that's just a by the way. You don't have to answer that.
Apologies, Chair.
No, that's fine. Now, in the bail appeal that you dealt with, the judgment appears at page 86 and 87, particularly page 87. You were dealing with a bail application on new facts. Well, it starts at page 878, and I'm focusing more on page 87. Paragraph 26 and 27 in particular. You
Yes,
there?
JP?
Yes. Now, you were dealing with a bail appeal on new facts, but you made the conclusion in paragraph 26, but then you went on and dealt with a previous bail application, which in my view was not before you. And you traversed the reasons why you believe the magistrate was incorrect there in having refused the bail application. That's how I understood that judgment. Was that necessary?
I understood that what I was required to do there was to deal with the evidence that was presented by the accused holistically. That is the evidence that was presented at the first bail application and the second bail application, not only the
No, but in paragraph 23, you do say the magistrate found, as recorded earlier, that the facts presented in the renewed bail application were not new facts, and you say you were inclined to agree, and then you state the reasons. And in paragraph 26, you make the conclusion about that bail on new facts, that it was the appellant was correctly not released on bail, but then you go into the previous bail application. That is my concern there.
I will be guided by you, JP.
I think the issue is you dealt with something that was not before you because it was the bail on the new facts that was now before you, not the previous bail.
Thank you for that. I take your point.
Okay. Then on page 61 of your application, you were dealing with that judgment on the stay of prosecution. But I was just interested on what you say about, in page 61,
Yes, JP?
on line, sentence number 2, it appears that the application to strike out was not heard, and there's no explanation as to why it was not dealt with prior to the main application being heard. Was that necessary, that there ought to have been a separate day for hearing the application to strike out, or it could have been dealt with at the same time as the main application?
It could have been dealt with at the same time.
Yes.
The issue here, JP, the issue here was that it was dealt with and a judgment was issued, handed down, and the applicant in that case did not accept it. It was one of those, it was a unique or peculiar circumstance where the applicant in this case, when the application to stay prosecution came before the first judge, the applicant asked for her recusal because the judgment of the trial court was attached to the founding affidavit. The first judge recused herself, and the matter then came again before the second judge, and he dealt with the application to strike out and issued a judgment refusing the application to strike out, which meant that the impugned judgment stayed on the papers. I was then faced with dealing with the main application, but when I arrived in court, the applicant wanted to deal with the application to strike out again, and raised the point that the impugned judgment is still on the papers, and that if I had regard to the impugned judgment, then I would form a biased view of the case. So I felt that this case could have been handled differently on the basis of the fact that there is this issue where the applicant does not accept the application to strike out. So at that time, it should have been handled separately and then at the main application. But in any event, that's what the result was, that I was then later on required to deal with the main application.
All right. I think I have one or two more questions, DCJ, if you may allow me. The judgment, that is the one on Tegeta and others, I'm more concerned on page 168, paragraph 150.
Yes, JP?
Yes, you found that the agency was self-created and that the application should be struck off the roll. But then you went on and discussed the matter further. And the concern, my concern is there is no explanatory note in the judgment as to why you did that.
I'm not sure if can I just have a look at it?
Yes? Paragraph 150 and 151 at page 168.
Sorry, JP, the paragraph again?
150. I find that the agency which the applicants now claim is self-created and the applicants are not without substantial. Did you find it?
Page 150.
No, page 168 at paragraph 150. Are you there?
Page 168, paragraph
50.
150. My apologies.
Okay, maybe to make it easier for you.
In book one of two,
I've
You
now
have the booklet?
found it,
Okay.
DCJ.
Oh, all right.
Thank you.
Oh.
Paragraph 150. I find that the urgency which the applicants now claim is self-created and the applicants are not without substantial redress in due course.
And you say the matter ought to have been struck off the roll.
It
then
ought
you-
to have been struck off the roll, but it appears that the parties then agreed that the matter would be heard on the opposed roll, which is why I then dealt with the matter as an opposed.
But as a judge, what is your duty there? And you've made that decision in paragraph 151. Why you then went on and dealt with the matter?
I take your point, JP.
Yes. So finally, I think, as I said, I am concerned about the concerns raised by AFT because they appear in our courts often and some of the colleagues. And unfortunately, I'm not able to say yes or no because you have not acted under my watch in Durban, or my respect for that matter. So that's where I will leave it. Thank you, DCJ.
Thank you, JP.
Thank you very much, JP. And just a tiny detail in defense of the candidate. A judicial candidate is entitled to list no more than 10, list and supposedly attach no more than 10 judgments in their application form. But I must indicate that I was also overwhelmed by this whole booklet that's dedicated to one candidate. And it's just that your judgments are long.
Yes, thanks,
Kirana.
DCJ.
It was the first judgment, the Optimum Minds judgment, that was very long, DCJ. My
Yeah.
apologies again.
All right. Premier? Premier,
Thank you very much.
oh, did you manage to join us? Welcome. Are you well?
Yes, I'm good, ma'am. Good morning.
Good
Thank you very
morning. Do you have any questions for the candidate? Premier?
Yes, ma'am. Thank you very much. Good morning. Can you hear me?
Yeah, although your line is not very good.
My line not good.
Yeah, just keep talking. Let's see if you can make out what you're saying.
Okay, thank you very much. My apologies for that. I just want to ask from Ms. Harrell, what is your view about the independence of the judiciary? Thank you.
Thank you for the question, Commissioner. The independence of the judiciary is most important and integral to the separation of powers and to the rule of law. The judiciary is often called on to deal with disputes that deal with organs of state, and the judiciary is required to be independent. I'll leave it there, Commissioner. Sorry, I have a blank for now.
Okay. DCJ, can I come through again?
Yes, carry on.
Thank you very much. I just want to ask from Ms. Hurwell, you talk about the separation of powers, but what we understand is in relation to those separation of powers, do you believe that there is sometimes another sphere of governance interfering or maybe overreach of other spheres of government, of state, sorry?
Overreach into the judiciary or the judiciary into the other organs of state?
To
Commissioner,
overreach into other organs of state. Thank you.
I understand that the judiciary has tried, from the cases that I've read in the media, that the judiciary has stayed out of the other organs of state, and there's been no overreach. Thank you, Commissioner.
Okay, thank you, DCJ. I'm done.
Thank you, Premier. Deputy Minister?
Thanks, Deputy Chief Justice. Yeah, just one or two questions really, Ms. Harilal. Good morning.
Good morning, Commissioner.
The issue's been raised about the Labour Court, and I think that was from the AFT submission. But I don't know if you've specifically responded to, I don't think it was specifically asked, but why haven't you applied to the Labour Court? Because your expertise does seem to be in labour law. That's the one. And then the other one is just a small question out of interest. Why did you only do a year with ICMEA attorneys for your articles? I see you say you moved to Durban, but Verulam to Durban is not far.
Thank you for the question, Commissioner. Way back in the 1980s, when means were not available and transport was a problem, one had to try and work closer to home, Commissioner. So that's why I had to move from Verulam to Durban. I ran a general practice when I started practice, and then I specialized in labor. I gravitated towards the industrial court because that was the work that was available to me. I had a passion for labor, but at the same time, that was the work that presented itself to me. I developed a passion for adjudication through that, and I've always wanted to be a judge. I did the best that I could at the Labour Court, and then I moved to the CCMA, which was an opportunity that made itself available to me as well. When I was invited to act in the High Court, I embraced that. I was very excited to be coming to the High Court because law, as a lawyer, you want to be able to experience all aspects of the law. And I got that opportunity acting in Pietermaritzburg and Durban. As I said, I did a full spectrum of law in most of the areas of the law. I didn't get an opportunity to act in the Labour Court at that time. And so I continued acting in the High Court, where I did the best I could to develop myself professionally and make myself available for appointment. I did not apply to the Labour Court because my last experience did not give me a good track record or a good performance record. and I did not believe that was going to hold me in good stead. And while I say that, I thought that J.P. Wagley was going to be one of the commissioners here today, because I did explain that when I experienced difficulties with the workload in the labor court, I had spoken to him and he understood the difficulties I had there. But after I had acted in the labor court, I was not invited to act there again. I was invited to act in the High Court, and so when the positions were advertised, this is the court that I applied to, because I've handed my judgments down here as quickly as possible. I don't see a problem with my track record here. Again, as I say, it pained me that over 28 years or so, it's 10 weeks of work in the labor court that caused a blot on my reputation, my work ethic reputation.
Thank you, DCJ.
Thank you, dear. Commissioner Singh?
Thank you very much, DCJ. Good morning, Ms. Sirona.
Good morning, Commissioner.
DCJ, I don't want to overexploit this issue about the Labour Court and the High Court, but I'm just trying to grasp from my own information. And, if there's anything else you want to tell us, because what we've heard from you, Ms. Sirona, is that the workload in the Labour Court is something that you found difficult to handle. You were not invited to the Labour Court. Were you aware of vacancies that existed in the Labour Court currently? Because was it yesterday or the day before? Yesterday, I think. No, the day before. We dealt with the interviews for the Labour Court. So I'm just trying to get an understanding of, for me, when I look at your CV, and forgive me saying this, but it's an expression. I mean, you take like a duck to water when it comes to labor issues, with hundreds of CCMA arbitrations and things like that. So is there anything else you want to say? I know you've said quite a bit about it to all the commissioners, but is there anything else you want to tell us about why High Court? Thank you.
Thank you for the question, Commissioner. I was aware of the posts that were advertised, and as I indicated, I elected to apply for this post. The reason for that was that I did not come out with a good track record with the Labour Court because I had all those reserved judgments. And I figured that I should concentrate in one place instead of applying in both places. I'm not happy about the fact that I had that number of reserved judgments in the Labour Court. That is something that still pains me. I feel the sting of the blot on my reputation, as I said, of my work ethic. It was a difficult environment, and I watched interviews yesterday where I saw that J.P. Wagley indicated to Judge Moshewane and agreed with him that the Labour Court environment is a tough environment. It's complex matters on a large scale. It's a busy role. The court is under-resourced. J.P. Wagley acknowledged when I spoke to him at that time that they were under-resourced, that I was the only judge. But it did not look good on my CV that I had this number of reserved judgments when I came to the interview. So I still feel the pain of that. I've had to try to live that down on my reputation. I think that's the only way that I can explain it. And I'm happy working in the High Court. I like the variety of the work that it presents to me. It's stimulating, it's challenging, it's exhilarating. The motion court work exposes me to a wide variety of work.
DCJ, just a follow-up, please. Yeah, as I see it, I mean, every court, as far as I'm concerned, is a difficult environment, whether it's a Labour Court, High Court, Supreme Court of Appeal. Now, what assurance can you give this commission that, if you are considered for appointment to the High Court, we won't have this issue of reserved judgments?
Thank you for that question, Commissioner. I've not had a difficulty handing down my judgments in the High Court. I've done them within the time. I can assure the JSC that my track record with the CCMA for 28 years should show that I am committed to work. When I make a promise and a commitment, I deliver. The difficulty that I had at the Labour Court is it's just unfortunate. And if you compare the two environments, the High Court works like a well-oiled machine. You are given your files in time. You have time to prepare, which is why I said that I'm always prepared for motion court. I don't have a difficulty with the workload. I don't have a difficulty with being given a trial or the reviews, appeals, any of those files. They are given to us in time. They are brought to us. We have sufficient time in between to deal with those. The Labour Court environment was being given files the day before to deal with complex CCMA reviews. A review from the CCMA is not a small file. They sometimes come a box per file. And you have to read those entire transcripts in order to write a review judgment. It's almost as if you are sitting in the CCMA dealing with that whole arbitration for 10 days or so, and then writing the judgment in order to find out or determine whether that judgment is, that the award is reasonable or not. So it is time consuming, and those files were coming late. If I could share, without embarrassing the Labour Court, but the staff at the Labour Court would confirm this, that apart from being given files late, on the one day I was given a file to read for a review. I read the whole file. I went and sat on the bench, senior counsel on both sides, and started to hear the matter. And then about a few minutes into the matter, I see that the argument that is being presented doesn't make sense to me. And I was shocked. I didn't know how to deal with it. But then I asked, by the way, what is your case number? And I discovered that it was the wrong file. I had read the entire wrong file. And I stood the matter down, senior counsel on both sides. I took an hour or so to read the papers. But the thing that I did, and it's something that we learn at the CCMA, do not postpone, deal with the matter. So I read the papers for an hour and went and dealt with the matter, and then I reserved judgment. But I didn't make the parties go away and incur the cost of having to come back. But that besides, that is the way in which the work is allocated there. So it's not my shortcomings in the Labour Court should in no way impact on the way I handle my High Court work. I love the way the work is allocated there.
I will leave it at that, DCJ. Thank you.
DCJ, may I just comment? Sorry, I just want to confirm.
Yes,
I just want to confirm, in fairness to the candidate, that her name has not appeared in the list of reserved judgments that were reserved for more than 3 months.
All right. Thank you, JP.
Thank you, JP.
President Molemelo.
Yes, thank you, DCJ. What I wanted to canvass with the candidate has already been asked by Commissioner Singh, but just one or two things. Your acting period at the Labour Court, you said it was 10 weeks.
Yes, President.
Was it continuous, 10 weeks?
No, it was from July till December. And thank you for this question because it will explain a couple of things as well. I did a pro bono week in July, and I picked up 4 judgments in that week that I had to write. I then acted in the Labour Court for another 2 weeks in August, a further 2 weeks in October, and in the whole of November into part of December until court closed. But in that intervening period, when I wasn't acting in the Labour Court, I was required to go back to the CCMA to complete outstanding part heards. And the call from the CCMA always is that we must deal with our matters expeditiously. We must not have our arbitrations hanging on for a long time because there are employees who are waiting to know what the outcome of their cases are going to be. So I've always had to leave the High Court or the Labour Court and go back to the CCMA to finish up part heards and to deal with matters and hand down those awards within 10 days. And I did an arbitration for the Johannesburg CCMA, which I finalized during August, I think it was, a matter that went on for many, many days. And then I finalized that award during August, September. I also in that time went during the recess to the High Court to complete a criminal trial, and I handed down the judgment there, a judgment and sentence. So in that period from July till December, I worked continuously in the various places that I had committed to work.
But is my understanding correct? Between July and December, there was a time when you actually had 30 outstanding judgments.
I picked up 30 judgments.
Yes.
Yes.
So there was a stage where the total count of your outstanding judgments was 30.
No, Commissioner, thank you for highlighting that. July and August, those judgments were handed down within 2 or 3 weeks at a time.
Okay.
October is when I began to feel the pinch because I was dealing with CCMA award and the High Court judgment that I was dealing with, and the times it now began to be a slippery slope. November, I was doing 15 to 25 cases per week, and there was no time to read all those files and hand down extemporaries, and that's where the judgments started to pile up. When I submitted my first application in December 2021, I think I listed about 17 to 19 reserved judgments there. Those had accumulated, and that is what I had to work through to try and have ready before I came to the interview here. And while I'm on that, President, I could have finished those judgments long before the interview, because I expressed some concern, and some judges told me, why don't you just do an order and then you can give reasons later on. But like I said, those are not easy cases to just do an order, because later on you come back and you try to reason why you gave the order, and it's going to be difficult if you have changed your mind. So I would rather go through those files properly and hand down a judgment that I'm happy with. In addition to that, what happened was that I had committed to acting in the High Court straight after the December holidays, and I did a crime session in Durban, which was a criminal trial with 21 charges and 64 witnesses. I completed that trial. I was given it on the first day. I completed the trial by the last day of that session, and then I reserved my judgment in that. And then I did a civil court session straight after that. And in that time, I was handing down judgments as best I could in preparation for this interview, so that I could say that I don't have any outstanding judgments. By the time I got here, I still had 3. I could have taken a shortcut and done a wishy-washy job, President, but I just did the best that I could.
Yes, and the 50 weeks that in which you were acting at the High Court, was it continuous or also intermittent?
It was intermittent, or from between 2017 until now. I would do a few sessions or terms per year.
And then go back to the CCMA?
Yes, and go back to the CCMA or to the bargaining councils.
The concern that I have is that at the High Court during those 50 weeks, you at least had time to go back, to get a breather. And in the exchange between you and the JP of that court, you agreed that the Durban High Court is a fairly busy court. And so you would not be getting those many breaks in between. You'd be in court practically every day, presiding over matters and having to give judgments in those matters. I'm a little bit perturbed, and I want you to give us the assurance that if you are appointed, bearing in mind that you will be in court now every day, you'd still be managed to hand down your judgments timelessly.
I'm not sure if I understand the question, President, but are you asking me about the times when I finished a session with the High Court and then went back to the CCMA?
The point I'm making is that because you were not acting continuously, you were not in court every single day. So even in situations where you had reserved judgments, you had time to go and work on those rejudgments, on preparing those judgments when you were actually not in court. But the difference is that once you are appointed, you'll be in court practically every day. So as you get reserved judgments, you still in court, adjudicating over matters and still have to deliver judgments. You will not, the point is you will not be getting frequent breaks in between to give you time to go and write those judgments. Do you understand the point?
Yes, I understand the question now.
Yes,
Thank
yes.
you, President, and it gives me an opportunity to explain how it is. I would act in the High Court, and then my livelihood comes from the CCMA work in the Bargaining Council. My acting in the High Court is a sacrifice which I make for my professional development and for the commitment and the fact that I want to be appointed as a judge for the contribution which I can make to the judiciary. But apart from that, I have to earn a livelihood, and my livelihood comes from the CCMA. When I finish in the High Court, and if I've got a few reserved judgments, at the same time that I'm working in the CCMA, when I've left, I've got to hand down awards, and the time limit, the deadlines there are 10 days to hand down those awards. So if I've left the High Court, say at the end of March, I'm immediately back in the CCMA, and I've got to deal with my cases as well as some long-standing part heards, which, because I'm a senior commissioner, I get those very complex ones that take some time to finalize. So I've got to pay attention to those. And when the awards come, those are very complex awards. It's like a large, long civil trial. It's time-consuming. It has to be done within a 10-day period. So sometimes the award has to take preference. But those judgments still, President, they are handed down within the 90-day period.
But this explanation you've just given, I'm sorry, President Wulemele, this explanation you've just given perturbs me highly, Ms. Hirara. If, as you say, you earn your living in the CCMA and you have to give the matters you deal with the priority, we all respect that. Now, what I don't understand is why you would accept an acting appointment either in the Labour Court or in the High Court, knowing that you have parted matters that require, an expedited disposition.
Thank you for that question, DCJ. My JP would know that when I acted in the High Court for the first time in 2017, I loved the work there and I really wanted to come back. However, for 2 years, I declined invitations to come to act in the High Court. That was from 2017 till 2019. If you look at my application, it shows the gap. I had several calls from the previous DJP, Madondo, as well as my current JP to come and act in the High Court. And I would have to decline because of my commitment to social justice. And there came a time where I said, okay, I'd like to I need to do some of the High Court work because I want to apply at some point. And I spoke to the senior in KZN, and he gave me some time off. But at the same time, where you have these some long-standing arbitrations in the CCMA, they are, and they probably watching this interview because I have their full support. I would make time available after the High Court where they would be calling for dates to come and deal with the matter. And I go there and the matter is scheduled for 5 days and the parties have removed the matter from the roll. So it's a two-way street. I also had to deal with my professional development, but as I said, DCJ, I've not at all dropped the ball as far as social justice is concerned and dealing with CCMA matters expeditiously. I've made sacrifices for that.
My concern is that this what you describe as a sacrifice for the benefit of the judiciary actually benefited you and not the judiciary, because my understanding of your explanation is that, well, it's what you said. You left the Labour Court with a long string of reserved judgments and went back to the CCMA. And when you got to the CCMA, you did not have time to catch up with the pending, the reserved judgments, because you had to prioritize the awards, that were some which had been long outstanding in the CCMA. So the matters that had been heard in the Labour Court had to wallow for a while you served the place where you earn your bread, as you describe it.
It may appear so, DCJ, but we had also come out of COVID at that time, the COVID period, the pandemic, and there were a number of partheads that were waiting to be dealt with. And that is when I dealt with, in August, September, with an arbitration that had been waiting during the COVID period. And that was a Johannesburg matter where the parties were not always available. When they requested a date, I have email correspondence. When they requested a date, I made myself available immediately.
Look, we've spent quite an inordinate amount of time on this aspect, but before we leave it, I just want to get an assurance from you that you understand that leaving the Labour Court with the reserve judgments, which you could not finalize in time because you had to prioritize the work at the CCMA where you returned after your acting stint there, actually prejudiced the Labour Court because those judgments remained outstanding for an unduly long period of time, and those litigants suffered while they were waiting to hear from you. You don't seem to want to acknowledge that there's a problem there.
I take your point, DCJ. I understand what you're saying.
All right. Sorry, Pres, had you finished? Okay. Professor Marumahai?
Thank you very much, DCJ. Good morning, Judge. Good morning.
Good morning, Commissioner.
Should you be successful, you will be sitting in motion courts. And sometimes you find that, and of course, I mean, with courts which have not yet went digital, as it were, you find that some affidavits will be put into court files without even the necessary authority. After the 3 accepted affidavits having been filed, like your founding affidavit, your supplementary affidavit, and your replying affidavit. And you'll find that sometimes parties will put in supplementary affidavits or even further affidavits. In those circumstances, when you are hearing the arguments and you find such an affidavit in the file, for you to accept such an affidavit, what should the party who filed such an affidavit have to satisfy you with for you to accept that affidavit?
Thank you for the question, Commissioner. The rule is three sets. A full set of papers is 3 affidavits. There shouldn't be an extra affidavit in the file, and certainly not without an application for leave to file such an affidavit. When such an affidavit is filed, it upsets the evaluation of the evidence based on those 3 affidavits that are allowed. I would deal with it either by disallowing the filing of the further affidavit.
Sorry, just to assist you, what I'm actually looking for is, yes, you need to make a decision at the end of the day. What should the party who brought in that affidavit have to satisfy you with for them to at least stand a chance of being successful in you accepting that affidavit? I'm just trying to see what do they have to do. Yes, they will have to apply for your indulgence, but in applying for your indulgence, what do they have to satisfy you with for you to consider that affidavit?
They have to show that the evidence in that additional affidavit is relevant and necessary, and it will be in the interest of justice to allow that further affidavit, and that it's not going to prejudice the respondent. Although the respondent will be given an opportunity to answer, but that is not going to prejudice the respondent.
Okay, thank you very much. Thank you very much.
Thank you, Commissioner.
Thank you, Commissioner Marumahai. JP Lam.
Sorry, can I just add to that?
Yes.
My apologies. And that it's not something new that should have appeared in the founding affidavit in the first place. Thank you, Commissioner.
Thank you, DCJ. Good morning, Ms. Hiralal.
Good morning,
Is it
Commissioner.
Harilal, ne?
Hiralal.
Hiralal. Oh, I got it first time right. Just as a matter of interest, did you use the researchers that are available in the Labour Court when you picked up those reserve judgments?
JP, Commissioner, I did ask Mr. Vilakazi about the researchers, and he told me that they were not available. There's no researchers. I believe I might even have an email, because I'm used to using the researchers in the High Court, and I thought that that was something that was going to help me, but I was not given that facility. Also, if I may point out that I understand that there is a briefing session a briefing with the JP before each session that you act. Judge President Wagley apologized to me on the telephone for twice, for leaving me out of the list on the email for such a meeting where I would have been briefed as to what happens in the Labour Court.
Okay. One last question, DCJ. Well, 1.5.
Go ahead.
The one question is, it's a follow-up. You say you prepared on the wrong file and only realized it was the wrong file when council were addressing you. But didn't you get a role or a roster when you were appointed, which tells you what matters you're appearing in?
No.
What do you mean, no?
No, Commissioner. I wasn't given a role. That is why I say that the court was handled, compared to the High Court, it was not handled in the right way. I was given files like the day before. I didn't have a copy of the roll in time. I got a copy of the roll maybe later on in the week, but not at the beginning. I would be told, okay, these are your 2 files, and I didn't understand how the roll worked in the Labour Court.
Let me understand this. I'm sorry if I'm belaboring it. You were not appointed on the Friday for the next Monday. You were appointed there was quite some time before you started, isn't it?
Yes, JP.
But what did you receive?
I would not receive my files as early as I had requested, and I do have emails to show, which I'd written to Mr. Vilakazi saying, I require files to read, and he would not have them ready. So I'd either go to the Labour Court to collect them on a Friday afternoon when they're ready, or on a Monday for the Tuesday, because Monday would be the reading day.
Okay, no problem. The half question, DJ, is, have you attended judgment writing courses?
I've attended surgery training, but not judgment writing specifically, and I do believe that I can benefit from a course of that kind if I am appointed.
I see. Because I looked at one of your judgments here where you simply go into the merits, and way down the judgment, I'm still battling to find out what's the matter about, what you're deciding.
Which one is that, JP?
Okay, let me show it to you now. It's the matter that involved Brian Edward Caniff. You've attached it. It's page 94. Yeah, Brian Edward Caniff and Mbusisa Comfort Ngogo and others. You see that matter?
94. Yes, I do, JP.
Yeah. So I see there's an order at the beginning of the judgment. And then when I go to, you say introduction, then you tell us about Brian, who the parties are, and then you go into the factual background. I went up to page 11. I still don't know what is this matter about. I don't know where you tell the reader of this judgment what you're deciding here.
Find the issues at paragraph 31, issues to be decided.
Which is well into the judgment. I think that's the point, because that's what I see in another judgment as well, that you then say what is to be decided here, well into the judgment. That's why I'm asking whether you've attended any judgment writing courses.
No, I haven't,
Yeah.
JP. And thank you for pointing that out. I will keep that in mind.
Thank you. I think the JP has heard you. Next time there's such a judgment writing courses, hopefully she'll include you.
Indeed, JP, my JP Poyo Lwati made it possible for me to attend the SAJE training in
Yes.
January this year.
Yes. My comment, DCJ, I think as a head of court, I think you are better placed in the labor court. That's where your expertise is. That's your daily bread. I think you should go back to that court and rehabilitate yourself. Thank you, DCJ.
Thank you, JP.
Thank you, Commissioner.
Commissioner Bernard?
Thank you, DCJ. Ms. Hiralal, just what is apparent from the range of cases that you've added is there's you grapple with some important procedural and constitutional issues, and they're varying. So your range of experience has been good in the KZN division. Now, about something like the Tracker K or Tracker Connect matter versus BE Women Training, where you grappled with the charge of an until order or whether to confirm it. And then on the other hand, again, in the Nick Garner matter is the application for stay of prosecution. So just to, on those matters, I mean, there were some important constitutional considerations also in your mind when you dealt with it. One can see that from the cost order and so on. So maybe you want to address the Commission just on your exposure to various types of matters, particularly these two and the constitutional issues involved.
Thank you for the question, Commissioner. Good morning. Yes, when you highlight those two judgments, I appreciate that I could have commented more as far as the access to justice issue in the stay of prosecution matter was concerned. And the other one is Tracker Connect, the invasion of privacy and the balance of power between the applicant and the respondent in that Anton Pillar award judgment. I appreciate what I take your point on that. I should have commented more. I have done other judgments where I've had to deal with the issue of pacta sunt servanda and whether it is applicable in a contract judgment. And I found that I had to balance the defense that the respondent presented together with pacta sunt servanda, and I dealt with it there, but I should have commented more in these judgments on constitutional issues. When I was preparing for this interview, I did a lot more reading, and I realized that, and looked at those judgments, and I acknowledged that I could have done better.
Yeah, I'm not being critical. I'm just saying, in your mind, it's just to bring that to the Commission as well.
Certainly, they were very much in my mind. Like I said in the Anton Pillar order, it was very much in my mind, the balance of power between the two parties. But I should have commented on that as well. Thank you, Commissioner.
Thank you, Ms. Hiralal.
Thanks, Commissioner Bernard. Any further questions from the virtual platform? No.
No, thank you, Deputy Chief Justice.
All right.
No questions, Deputy Chief Justice.
Is that Commissioner Posoli Rutori?
Yes, Deputy Chief Justice.
Or how are you feeling today?
No, I'm feeling much better, thank you.
Oh, that's a relief. Ms. Hiralal, we've reached the end of your interview. Thank you for making yourself available for the vacancy. You're excused.
Thank you for the opportunity, DCJ. Thank you, Commissioners.
no, Good morning, Professor. Is it professor or advocate? Which do you prefer?
For practice purposes, advocate. Deputy
All
Chief
right.
Justice.
Well, if I'm to refer, I'm to address your advocate's cap, then it will have to be Mr. And I don't want to demote you, so I'll just call you Prof.
Thank
How are you?
I'm fine, thank you, Deputy Chief Justice.
You were here exactly around this time in 2022, weren't you?
Yes, Chief Justice.
What have you been up to in the past year? Have you been good?
You mean the previous interviews?
No, I mean, what have you been doing with yourself since?
Well, after my previous appearance before the JSC, I've been afforded opportunity to act. And when I came here last time, I've acted for 40 weeks. And now I've acted for 55 weeks. Last time when I came here, I've written 53 judgments. Now I've written 70 judgments.
Wow.
And in the meantime, I have then progressively acquired skills and practice in judging.
You've been busy.
Yes.
No, that's good to hear. Let's backtrack a little. You have 4 degrees, a BURS you obtained from Forte,
Correct, Deputy.
and LLB you got from VETS,
Correct, Deputy.
and an LLM from UNISA,
Correct,
and an LLD from UNISA.
correct.
And what's your area of specialty? What was your LLM on?
My LLM was on fundamental rights, and my LLD was on supervision of local government under the new constitutional dispensation.
You wrote a book as well, didn't you?
Yes, I wrote a book published by JUTA on supervision of local government.
You developed it from your thesis for your LLD.
I developed it from my thesis and add few things.
All right. For the benefit of those who have not heard you while you were on that seat before, you have had quite a remarkable career. You started out as a police officer,
Yes,
and in that sphere you worked your way up to the rank of sergeant.
yes.
You would have joined the police force straight from high school, but you were 20 or somewhere around that age.
Yes, I was 21 years old. Fresh from school.
And then you left the police force in 1988
Yes.
to do articles
No, to
of
study.
clerkship.
To study at Forte.
That's not what your CV says, though. It says, oh, sorry, you're quite right. It says you're a police sergeant from 1 January 1987 until December 1988. All right, no, I'm confusing you with another candidate. So you left the police force in 1988 and went back to university, back to school,
Yes,
and did your recent LLB, I imagine?
that's correct.
All right. And then you started your articles in 1996.
Yes.
How long were you at the sidebar?
It was 4.5 years, Deputy Chief Justice.
And you were a principal attorney of your own firm
That's correct.
by the time you left
Yes,
the profession, and then you went back to public service
yes.
to do what?
I went back to Department of Safety and Security there. I was the head of department, and then I joined municipalities. I've been a municipal manager.
In 2 municipalities
Yeah,
for a period of 5 years, I see.
yeah.
But during that time, you also chaired the Appeal Development Tribunal.
Yes.
What kind of work did you do in that body?
Well, it was to do with development tribunal. So whenever there is development, then they will apply to the development tribunal to approve those development. And then I was sitting there on the appeal board.
Okay. But then you left all those things and decided to join the academia
Yes,
to date.
yeah.
Which subjects have you taught in your academic career?
When I was at Northwest University, I taught family law, interpretation of statutes, and property law. And when I joined UNISA for the first 4 years, I taught law of evidence and civil procedure. And after that 4 years, then I taught constitutional law and local government law.
Right. But then in 2021, you decided to join the bar.
Yes.
Do you still teach?
I do pro bono. I only promote masters and doctoral students for UNISA.
Okay. You have published several legal articles in
Yes.
these areas of specialty
Yes.
of yours. How many? Are they too many to count?
I cannot remember, but there are many.
Yeah. All right. You have already told us about the length of time you have had on the High Court bench. You said it's how many weeks?
55 weeks.
55 weeks.
Yeah.
And I imagine that during that long period of time, you've sat in both the civil and criminal courts,
Yes.
doing a wide spread of work.
Yes.
Okay, both civil and criminal
Both civil and
trials and appeals and motions.
Yes.
Okay. How many judgments? 70?
70 judgments.
Okay. Any of them reported?
No.
All right. Any appeals taken against?
Yes, one appeal was taken and my judgment was overturned. It was a full bench judgment on criminal appeal.
Okay. When you were last year, there had been an objection against your candidature. Well, it was a concern really that you did not have sufficient experience to be permanently appointed to the bench, and it had been suggested. It was from the AFT, and they suggested that you should be given further time in an acting position, which happened. And they have come back now, and they report that you have improved. To use their words, you've improved tremendously during your acting stints. And they and the other professional bodies who have commented speak well of your judgments, and they say they support your candidature.
Yes.
You would not have any complaints against that, I imagine. Okay. All right. I am going to give the commissioners a chance to put questions to you if there are any. And we will start with the Judge President of the division to which you are applying, JP Boyolwat.
Thank you, TCJ. Good morning. Like the TCJ, can I call you Professor?
Thank you, Judge President. Good morning.
Good morning. I want to emphasize Professor because I believe that's where your strength is as a professor, as an academia, with lot and extensive background in that field, unlike being an advocate where you've been for 2 or 3 years only?
Yes.
And how has your academia background assisted you in writing your judgments?
Mr. President, it have assisted me on many ways. Firstly, with regard to extensive training on research, I do my own research, and also training on typing. I type my own judgment and make work easy for secretaries. Further, the knowledge, analytical skills that I acquired in research and academic, I found them to be useful in analyzing cases, in hard cases. So they've been very helpful.
Yes. You have acted during the time when I have been the judge president, both in Durban and in Pietermaritzburg.
Yes, Judge President.
And in particular, Durban, how have you found the workload?
Durban is a bit different from Pietermaritzburg. Durban is very busy, and there are a lot of issues like your Rule 43, your urgent application, but I've coped with the workload.
Yes. Those are the comments I've received from some of my colleagues about your performance, that you seem to have coped well, and you haven't complained once when more work was put on your desk.
Yes.
In fact, most of them that I have spoken to. Most of them also, I think the age issue has become irrelevant after their recommendations yesterday. They believe that you worked well, contrary to what one would think, particularly if one has regard to your age, which is about 62. I have nothing about age, I must be upfront. I was also quite impressed when you came back to me when your criminal trial role collapsed and you made yourself available.
Thank you, Judge.
Yes, and in there, I gave you an opposed application, which within few hours, I think because it was dealing with local government issues, you were able to come back and identify the issues and confer 1 or 2 things with me.
Thank you.
Yes. Now, the only issue that seems to be raised, as something that we must take into account is the judgment from the Supreme Court of Appeal, S versus Pile, where the judges, they say that you ignored certain facts when you decided the matter.
Yes.
That was a full bench decision. You sat with the retired Plus van Amstel J.
Yes.
And he agreed with you. It was
Yes.
Yes. What are your comments to the comments of the Supreme Court of Appeal?
Thank you, Chief Justice. The judgment itself was a bit complicated because it dealt with interpretation of statutes. It dealt with interpretation of Section 93, Tier 1 of the Magistrate Court. And there have been sharp judicial opinion on that issue. There have been a lot of conflicting judgments. In Eastern Cape, there was Lichona judgment. In Gauteng, there was Ngomane judgment. In KZN, there are about 4 judgments. All these judgments actually were conflicting. And my interpretation of Section 93, which provided whenever an accused person is stand trial before a regional court magistrate, the magistrate must be assisted by 2 assessors unless the accused person requests that the matter can proceed without assessors. So in interpreting that Section 93, I opted to follow the KZN division, especially the case of State versus Nomalo, which was Lob's J judgment. I regret, JP, that there was an oversight on that. I should have thoroughly interrogated all judgments.
Yes, but what interests me, as you have said, there's a lot of divergent views on that issue, and hopefully soon the CC might pronounce on the issue, because there still continues to be, because it seems to have been the issue that the accused rights were explained at a pre-trial conference, and I don't know whether it was a different magistrate in terms of the assessors.
Yes.
And then also at the trial, there was no explanation. So I don't know if you recall, was it a different magistrate that dealt the pre-trial and a different one that started the trial?
Yes, Judge President, it was a different magistrate at the pre-trial, and it was just a rewriting hand note, which actually did not explain what exactly was explained to the accused person, because then I was taking from the Gaia judgment, where paragraph 8 of the judgment, so Supreme Court judgment, where it was stated that the starting point is that the regional magistrate should inform the accused person that as a matter of law, he or she is required to sit with assessors. And what then happened in this judgment is that there were retyped notes that the accused was informed of assessors, understood, and Laikman, who was the attorney then, confirmed that the court may dispense with assessors. And during trial, the magistrate, which was then a different magistrate, wanted to know from the legal representative whether he confirmed whether the issue of the assessors is still the case. So then I was of the view then that because the Natal division, in about 3 cases, Hlachwayo, Ngumalo, have actually decided that, firstly, the magistrate should inform the accused person. It should talk direct to the accused person, not through an attorney. And the accused can only make a choice whether he wants to dispense with the assessors once the accused person has understood the nature of that Section 93. That was the issue.
Yes, and in such matters where the conviction and the sentence have been set aside, it's up to the Director of Public Prosecutions to reinstate those charges because it was a technical issue. Am I correct?
Yes.
Yeah. And then finally, there's a full court decision. I don't know if you know about it. I think you were confirmed by Stein, Bezedenot, and Gosij, but it almost caused a conundrum in my court because they were not agreeing on the order. But ultimately, after lots of talk, you were confirmed. It just shows the extent of the complexity of the matter, where 3 judges were seeming to not be agreeable. But as I say, in the end, we do have an order. Thank you, TCJ.
Thank you.
Thank you, JP. Premier Dube.
Thank you very much, CJ.
We seem to have lost you. Are you still there?
Okay, yeah, there you go. Can you hear me now?
Yes, we can, and see you too.
Thank you very much. Just to ask, Prof, especially that Prof exposed to local government, and I always feel that there is a need for more work to be done around matters of local government, even around issues of traditional leadership as pertaining to local government. We've seen a number of judgments that delay when it comes to issues of local government. What do you think, in your view, is impacting on those long outstanding judgment when it comes to matters of local government?
Thank you, Honorable Premier. Firstly, it impacts a lot because local government, as the released sphere of government, there is concern with delivery direct to the people. And whenever this matter take too long in court.
I'm sorry, Prof. Matenja, you soft-spoken. Can you just speak closer to the mic? I'm struggling a bit to hear you.
Thank
and
you.
I'm hard of hearing.
Thank you. Local government is a sphere of government that is closer to the community, and it's a sphere of government that is concerned with service delivery. If judgment are delayed, then it means that because judgment will be delayed because there are disputes between the parties, then service delivery will be affected. Therefore, knowledge and adequate application of local government law within a reasonable time, it's important.
Maybe DCJ, what do you think, Prof, should be done then to ensure that we avoid such delays? Because, as you correctly say, it does impact on the lives of people, but also it impacts on the efficiency in the delivery of services by government.
Judges, like all other people, are accountable. Therefore, the value of accountability requires that judges should deliver their judgment in time, because if they do not deliver their judgment in time, then they are failing the very value of accountability enshrined in the Constitution.
Okay, thank you very much, DCJ.
Thank you, Premier. Do you have any questions, dear?
Good morning, Prof. No, I have no questions.
Good morning, Judge President.
I thought you were going to say molo mhlobo wam. Sorry? I thought you were going to hola molo mhlobo wam. That's what you threatened. Prof. Marumo Khai.
Thank you very much, DCJ. Good morning, Prof. Matuja.
Good morning, Prof.
I have a question for you arising from the judgment that you penned. I'm just trying to. It is a judgment that dealt with the intersection between the Recognition of Customary Marriages Act and the Administration of Deceased Estates Act. You remember that judgment? I'm just
yes,
trying to get to it now.
Strang versus Straba.
Yes. And I'm not criticizing the outcome, because I think you are probably right. But I'm asking you because of the difficulty of these kinds of cases and some of the judgments that have came. And of course, one needs some clarity when reading these kinds of judgments. One, the the marriage was declared valid post the death of one of the parties.
Yes.
Yes. And in paragraph 1, you state correctly that this is the applicant seeks an order declaring the customary marriage to be valid. And then you deal with Section 3 or Section 1 of the Recognition Act, the requirements of the marriage. But it doesn't seem to me that you grapple with what authorizes you to declare the marriage valid, even though the deceased is no more. I mean, it is possible, but in your judgment, it doesn't seem like you deal. It seems like you take it as a granted that that can be done. I'm not sure if it is just stylistic or do you have anything to say about that? Because when one reads these kinds of judgments, one would want to understand on the basis of what would that kind of order be made? Because somebody because some of us, we are teaching, you know that. So when I'm using this judgment to teach family law, students might ask, but is it possible for a marriage to be declared valid when the person is dead? I mean, you and I, we know it's possible, but I'm just saying from the judgment, it doesn't seem like you grapple with that.
Thank you, Prof. The starting point is that, as you know, it's not a requirement of the customary marriage that it should be registered. So there was then evidence, there was affidavit from the deceased family, from the husband family, from the traditional headman who was present when the marriage was officiated. So based on that evidence, and based on the fact that it is not a requirement that customary marriage...
My apologies, Prof. I'm asking a different question. You are right. There's no requirement for that marriage to be registered. The Section 4(9) of the Customary Marriages Act makes it absolutely clear, notwithstanding the non-registration of that marriage, that cannot invalidate the marriage. It can be registered later, even years later. I have no difficulty with that. I'm more on Section 4, subsection 7, which allows you to declare this marriage. But the question I'm asking is, why don't you deal with Section 4, subsection 7, which at least just to show that I'm going to grant this order based on this provision. That's what I'm conversing with you.
I felt it was important, firstly, to declare the marriage that it was a valid marriage so that the spouse could be appointed as the executor based on the fact that she was the wife of the deceased. If the marriage was not declared valid, then how would one say that the spouse was the wife of the deceased? That was my reasoning.
Well, I'll leave it there. Thank you very much, DCG.
Thank you, Prof. Commissioner Singh.
Thank you very much, DCJ, and let me declare that I do know the good professor. If you look at his answer to question 8, he belonged to an organization that I belong to and still belong to. But he's not there anymore. But notwithstanding that, Prof, I think I want to take advantage of the fact that you've been an academic, and a very good one at it. You must have heard the CJ announce the other day that academics will be allowed to apply for vacancies in the Concord. I just want to know, in terms of your experience as an academic, where do academics find time to sit on the bench? Because you'd either have to go on sabbatical or resign from your position. What happened in your case, and what informed you moving from academia to the bench? Thank you.
The only reason why I took early retirement is when I was given stint to act. Firstly, I applied for leave, then I was given 30 days. But then I realized that because my passion now was with the bench, I rather resign so that in case I'm given more stint to act, I'm available. Then it worked, because after resigning from academic, I was given more stint to act.
So that would seem to be a calculated decision. which worked out for you. But generally for academics, I mean, what position will they find themselves in? You were fortunate that you had acting positions, and then you are here before us today. But generally for an academic, because it's well and good for us to say that academics can apply to the Constitutional Court, but practically, will it not be a bit problematic?
Well, universities have different policies. It depends on the policy of the university. They have different policies. Other universities allow academics to practice, and if academic practice, that in fact enriches their teaching because they combine practical and theory. So for me, depending on the policy of the university, that is workable.
Thank you, DCJ. I've been enlightened, and I think we've been enlightened.
Yeah.
Thank you.
No, thank you very much, Commissioner Singh. Are there any questions for this candidate? Oh, JP Mlambo.
Thank you very much, Prof. Good morning.
Good morning.
By the way, me and you last met during the sergeant training, isn't it?
That's correct, JP.
Yeah, and I take it you've given up on me. That's why you're sitting here today for KZN.
JP.
You don't have to respond. Just to follow up on this question about academics, my experience is academics struggle to, those in full-time employment of the universities, they struggle to avail themselves. They can only do so when they are on sabbatical, mostly. Because they've got responsibilities to their students and the university.
Yeah.
How have you managed to bypass those problems?
It's correct, Judge President. That bothered me a lot, but that is the reason. When I resigned as an academic, I still had a lot of years to go as a full professor, but I have to make a choice because then I was invited to act. Then I realized that because in academic, your clients are your students should be prioritized. Yes. Then I thought I rather resign, hoping that I'll be given more acting stint, and that happened.
Yes.
Yeah.
My other half question, DCJ, is I've had a number of academics coming to act in Gauteng, those who were able to do that. And my experience is that if you put them in work areas like unopposed motions, and I think civil trials as well, they tend to struggle somewhat with the procedural issues of hearing the matters, but on substantive issues, they don't have a problem. What was your experience?
It's true, Judge President. My experience was different because firstly, I served articles as an attorney, practice as an attorney. I served pupillage as an advocate in Pretoria, practice as an advocate, I was an academic, so I have that combination of, but motion court, it's very challenging because motion court, you are on your own as a judge. If you are not familiar with the court procedure, you are likely to struggle. I agree on that, Judge President.
But your experience, as you say, serving articles and being in practice, didn't helped you, that is, in coming to grips with the High Court litigation?
It helped me a lot, Judge President, because in most cases I will even refer to my pupillage notes because everything is contained there and developed from there. But whenever legal representative said something, because I will know where to get the answer.
Yeah. And my last question, DCJ. I think in all fairness, I put the same question to the previous candidate. Your judgment in the N2 eco-fuel CC matter,
Yeah.
you decided a number of issues there. I mean, the order says you dealt with a special plea, 2 special pleas, as well as non-joinder. But there was also an application to strike out in that judgment. Now, as I say, in fairness to the other candidate as well, when I read this judgment, I read throughout until you dealt with the application to strike out and then you went further. I couldn't find anywhere where you tell me early on what are the issues in this matter, what are you deciding? Am I being unfair on you?
No, you are correct, Judge President. Even in the course that I attended on aspirant judges, that was emphasized that you should state what are the issues involved. I've done it in other judgments, but for some reason there might have been oversight on this judgment.
Yeah.
Yeah.
No problem. I think your judgments generally are short, to the point, and succinct, and that impressed me. And if I may say this, DCJ, during the course that Judge Matopo ran, that I'm talking about, the Prof was one of those very actively involved participants in that course, including another Prof who's sitting in this room, whose name shall remain unnamed. Thank you very much, DCJ.
I think we can guess with accuracy which other prof that is. Commissioner Bernard?
Thank you, DCJ. Prof, I want to just take a matter further that was raised by the JP, and that is specifically the matter of State versus Pillay. It seemed to me that the explanation given was more with reference to the law and maybe the challenges in that regard. But the judge, the High Court does say the SCA at least does say in paragraph 41 that the High Court ignored the facts as disclosed on the record. And then again, later on in that paragraph, it erred both in respect of the law, its in respect of the law, relating to the section and in its application to the facts. So specifically on the factual misreading, it seems like the court, yourself and Judge van Amstel, missed something in regard to the facts there. What have any comment on that?
No, thank you, Commissioner. It's true. It seems as if the statement in the pre-trial conference, firstly, that the accused person were informed of the use of the section, they understood, and that the attorney confirmed that they can do away with the assessors, and thereafter the accused person also confirmed that. I think the Commissioner, it boils down to the very interpretation, even that is reflected to the record. It can be said we overlooked that, but our interpretation at the time was that if the regional court magistrate did not explain the nature of Section 93, that will be irregularity. That was our interpretation at the time.
Although it seems that if one reads the appeal case, the Director of Public Prosecutors, KZN versus Pillay, then it seems that the court says that the magistrate did make a note that was explained in court. So it seems like that note was not accepted by yourselves.
No, Commissioner, it was not explained in court. There were notes, handwritten notes of the pre-trial conference. In court, all what the magistrate says was to ask the legal representative whether it is still the case that the assessors were not needed.
Thank you. I'll leave it at that. Thank you.
Thank you.
CJ, thank you.
Thanks, Commissioner Bernard. Prof, there are no further questions for you, so that means we have finished your interview. Unless there's anything you want to say to the Commission, you are excused, and thank you very much for making yourself available.
Thank you very much, Deputy Chief Justice.
Colleagues, as the candidate makes his way out of the room, can I ask something? Do you mind terribly if we forgo our lunch break? It is possible for us to go to the bathroom and get a cup of tea or something as the proceedings carry on. I raise this because some of you would have early flights to catch, I'm told, and would like to finish early, and we can only do that if we don't take many breaks. How do you feel about that? No, just the tea break. Did I say lunch or no? Slip of the tongue. No, lunch break. No, we have to eat. I meant tea break. Well, Commissioner Klaba has spoken that Good morning, Ms. Smart.
Morning, morning.
How are you?
I'm very well, thank you, and actually much less nervous than I thought I could be. Flies, so yes, thank you.
No, you need not be nervous. We don't bite. Are you ready to start?
I'm ready, thank you.
Okay. Your CV tells us that you worked mainly in the hospitality industry from 1978 until 1996 when you went to the bar, doing
Yes.
various things exciting things such as waiting tables and so on. But I noticed that you obtained your legal qualifications around that time. So were you studying part-time? Well, at least did you do the first, the BA part-time?
Yes, that was through UNISA, part-time.
And then you went to the University of Natal thereafter to do your LLB?
Yes, the 3-year LLB.
And a while later, you obtained the postgrad diploma in environmental law. Did you put yourself through university? That's the impression I get.
Yes, I did, yes.
Oh, that's commendable. So you joined the bar in 1996, the Durban bar, that is.
That was the end of 1996, yes.
And that's where you still are.
Correct.
What kind of work have you done? I mean, in how many years?
I think it's about 27 years. A variety. In the beginning, obviously, we had we were in the fortunate position to be allocated pro deo, so we cut our teeth at that early stage on court work and criminal work. And then after that, it was just general litigation, whatever came along. And in the last few years, primarily corporate law, insolvency matters, and recently in land claims court, which I quite enjoyed.
Yes. Well, your experience is not unique. I think you speak for all of us, especially the women who started practicing around that time. Were it not for the pro-deo system, some of us would not have made it at the bar. So that kept us going until one could get work, and you could not be picky. You took whatever scraps were there for you. So I fully understand where you have been. You started acting in the High Court when?
I had one stint in 2019, and then nothing until last year from July, and then periodically since then, a total of 28 weeks.
28 weeks.
Including the 2019 session.
All right. And you sat in both the civil and criminal courts?
I sat in the criminal court for one session, but during the civil sessions, there were quite a few criminal appeals that I dealt with.
Yeah. Did you do any civil cases?
Civil cases, yes.
All right. Did you write any judgments?
Yes.
How many?
I think in total, which were reserved, were about 8, but a lot of the judgments, most of the other judgments were ex temp.
All right. Any of your judgments reported?
No.
All right. Any taken on appeal?
No, not that I'm aware of.
No.
And, well, nothing up until now.
The professional bodies have, as you would know, have written in about your performance in the division. And the African Transformation
Advocates for Transformation.
Advocates for Transformation speaks highly of you, and they claim, they proudly claim you as their only white member who has done good things there, mentoring black juniors and so on, and they support your candidature. But the GCB has expressed concern about the period of time you take in delivering judgments. I will not take that any further with you. I'll leave it to the JP to probe further. But
I'm sure that's the big elephant in the room that will be
Yes.
discussed quite,
yeah, you'll
quite
have
a
an
bit.
opportunity.
I recognize that. Thank you.
Okay.
Thank
All
you,
right.
DCJ.
Okay, I'm going to ask the commissioners to put questions to you if there are any, and the JP of the division will go first.
Thank you, TCJ. Good morning, Ms. Smart.
Morning, JP.
Yes. In the 28 weeks that you have acted, how many weeks have you done in Durban? Do you recall?
Well, I know that I've done about 9 weeks in Pietermaritzburg, so it would have been the difference between that. So it's probably 19 weeks,
Have you found
17 weeks.
Have you found any difference between the two divisions?
Not really in terms of workload. What I have found is that, well, when I practiced, Pietermaritzburg division has certainly become almost as busy as the Durban court.
Yes. And I see that you've done only one crime
Yes.
stint. Do you know why that is so?
I haven't, no reason. I haven't been asked to act
Allocated.
again. Yes.
Yes. Now, in that crime session that you have done, I am told, and I think it's something within your knowledge, that you took a few days to write a judgment and you refused to start a new trial. That is what the DPP's office reported to me.
During that session, I don't know if you recall, there was a problem with the lifts. So there was about 4 or 5 days where we couldn't sit. So that then took us up to the end of that session. The reason I was reluctant to take on a new case after that is because I didn't want to sit with a reserved judgment.
Yes, but
with an unfinished judgment.
yes, but you lost in it. That was my understanding is that the fact that the lifts were not working was a couple of days and more days because you were busy with your judgment and you couldn't start a new matter.
Yeah, well,
and a senior criminal judge had to speak to you about
yes,
that.
yes.
Yeah.
And but that was before. That was at the beginning of the session, and I accepted that I would have had to have taken on another criminal trial. But it just so happened that we seemed to have run out of days.
Yes, that concerned me a lot because we've got a backlog in criminal matters, and judges, as they do often, will take a day only to deal with criminal judgments, or you simply adjourn and deal with it over the weekend. Now, when you lose about 4 days only for the judgment, then you have the system, well, the infrastructure issues, then it added more. So we could have probably finished another criminal trial then.
Yes.
Yeah. Now, the reserve judgments, which you said it is indeed a big issue for me. I've received a spreadsheet from the researchers. The one matter that concerns me in particular is K. Swindon. It's a civil trial which you completed in December 2022, and have you handed down the judgment?
That was handed down this week, yes.
This week?
Yes.
So that's about, what, 9 months?
10
or 10?
months, yes.
Yes. Now, if you take that long as an acting judge to hand down a judgment, And that is not the only one. The other one that I'm concerned about, MI Zulu and others versus the Provincial Executive Committee of the ANC, the African National Congress, KwaZulu-Natal. There you took 7 months to hand down the judgment. And then in another one, and I think I had to write to you with this one, for Nene versus Minister of Safety, you took 6 months. There's another one you took 6 months, another one you took 5 months.
Yes.
How are we going to cope afterwards if you take that long as an acting judge?
JP, it's a lesson that I've now learned. It's a hard lesson. The longer you reserve a judgment, the worse it becomes. It does, become difficult to get back into it. In my last session, I did have 2 days where I had appeals, and in both those cases where I was a scribe, those judgments did come out within a week or 2. And other than that, I haven't reserved judgments. So it was the Nene judgment. It was a trial that was allocated at the beginning of my Pietermaritzburg session, and after that it was a non-stop. I couldn't get around to doing anything, and then getting back into practice, trying to keep up with or catch up with work. But it is something that affected me a lot during that time. It unfortunately didn't push me hard enough to finish it, but it was very much a kind of psychological block almost. But I certainly think that it's a lesson that I have learned and hope not to repeat it.
It's a concern because we're not talking about 1, 2, 3. We're talking about more than 3.
Yes.
And I regard you as a seasoned practitioner. You've been around for more than 20 or 25 years in practice. Why is it taking you so long to write the judgment?
JP, I don't know whether
because let me just tell you, the one for Nene, for instance, Minister of Safety, would have been probably an unlawful arrest.
Yes.
So why would it take 6 months?
JP, in that case particularly, I was quite torn between finding for the plaintiff, and I really had to. It seemed as if what I wanted to do was find for the plaintiff, and it took me quite a while to sort of do enough research and look at the evidence again, rewrite it when I was sort of almost absolutely convinced that there was no case in favour of the plaintiff. So I think it may have a lot to do with probably too pedantic. I think too much. I reflect too much about a matter. I really want it to be right, and perhaps that's a fault that I have.
So you battle to make a decision?
I think in short, probably yes.
Yes. Now, just 1 or 2 other things in the judgments that you have attached. The one that I think you were sitting with Stein J. It's a full bench appeal. It also raised the issue. The court, Meremoto, raised the issue of the Section 9310, which was not complied with.
That was in 20. Was that the recent one? Is that
It's a May 2019 case,
yes.
And I'm referring to page 29. What I want to know is, because it was not raised as a ground of appeal or in the heads, did you give the state notice that this is an issue that you want to raise so that they could prepare?
I don't recall whether there was any formal notice given to them, but I do recall that was when that was the first time I was made aware of Section 93 and I recall it was a big discussion that I had with Judge Stein.
Yes. And then you concluded that once you had dealt with that point, that the appeal must be upheld, but you still went further and discussed the merits of the matter. Shouldn't that have been the end of the matter?
I'd always believe that if there is a point which it would be dispositive of a matter in an appeal situation or in any trial, if you can deal with the merits in the event that it does go for a further appeal, that the appeal court would have an understanding of what the court au quo had on the merits.
And then finally, is there a reason why you haven't attached a judgment in the criminal matter?
Because that was an extempore judgment, and I didn't have a confirmed copy of it.
But you would have written your judgment?
Yes.
And you would have read it in court?
And read it in court,
Yes,
yes.
and you could have attached it here, so that we can assess your knowledge of criminal law, because as I understand it, it's not an area that you have practiced in before.
No. It was, as far as I recall, it was 90 pages of notes that I did read out. There's no reason why, I can't give a reason why I didn't.
I think I will leave it there. Thank you to CJ.
Thank you, Jackie.
Thank you, JP. Premier, do you have questions for this candidate? Oh, there's a follow-up, Premier. Just give us a moment, JP Mlam.
Okay, all right.
Advocate Smart, good morning. Just one question. Have you ever attended such a aspirant judges training?
I did at the beginning of this year.
Were you present in the one Prof. Matenja was in?
Who? Sorry?
Prof. Matenja, the previous candidate.
No. I think he was in a previous one. I was in January this year.
Okay. Thank you, DCJ.
Thank you, JP. Premier?
No, thank you, TCJ. I'm okay, thank you.
Thank you.
Thank you, Ms.
DM, do you have questions for this candidate?
Thanks, yeah. Advocate Smart, I see you, from your CV, you were a small claims court commissioner from 2009, but only for 5 years.
Yes.
Why did you stop appearing in the small claims court?
Why did I start, or why did I
Stop.
Commissioner, I had moved out of Durban into an area which is sort of fairly semi-rural, and the travel and being at magistrates' court late at night, I was getting a bit concerned about that. So that was really the reason why we had tried. There was a discussion about small claims court being held earlier, but the vote was against that. So it was purely for safety reasons.
Okay, thanks. What other forms of community service do you do? You spoke about pro deo matters.
In the beginning.
Yeah.
I'm involved in the pro bono committee and have been for a few years. So just in terms of allocating pro bono matters, sometimes I take some pro bono matters myself. And I'm not sure, advocacy training. I lectured previously for the pupils.
Okay, because I was a bit concerned with the JP's, when the JP was questioning you, it's sort of not that detailed, but more what it reflects on, of not wanting to take up a case because you didn't want a part heard or another reserved judgment. And that doesn't reflect well on the users of the system, the parties in the case. So I'm looking for something to try and assure myself that you do see the public, the participants in a case, as very important and people who need to be to need to have their matters addressed.
I do believe that is very important, that there should be speedy justice. The reason I did not take on that second criminal trial is probably, that it is what it is. It was my first criminal session, and my concern was that it would run longer. It might have been more of an intrusion on, I didn't know what the future was holding at that stage.
Okay, thank you. No further questions.
Thank you, Commissioner.
Prof?
Thank you very much, DCJ. Good morning, Advocate Smart. I'm here. This side.
Good morning.
Yes.
Morning.
I want to take you to one of your judgments. Now my screen is just the one that dealt with it was an appeal from the magistrate court. I just want to take you to the relevant paginated page. I think it is paginated page 28 of your bundle. It is not clear on that page as to what the name of the parties are, the citation of the judgment, but it starts there nonetheless. And I want to take you in particular to, well, this was an appeal against conviction and sentence from the magistrate court for robbery with aggravating circumstances and murder.
Yes.
Yes, I want to take you to paragraph 25. It is on page 29 of that document. And I want to continue from where the JP ended when she said that she wanted to test your criminal law knowledge. I want to take it further and take it to criminal procedure and evidence. I'm not sure, are you there?
I am, the child witness.
Yes.
Yes.
And this is not your doing. I mean, in the trial court, the magistrate received evidence from 5 witnesses, one of whom is a 13-year-old. In your judgment, you say 13-year-old youth. I'm not really sure if you can refer to a 13-year-old as a youth, but besides that, what I'm concerned with is, because on their ground of appeal, what they are raising is the magistrate failed to assess whether the child understood the difference between telling the truth and not telling the truth.
Yes.
I'm not concerned with. I'm concerned with an issue that I don't think the representatives raised, and it doesn't appear as if the judges raised as well. This is the child witness. The Criminal Procedure Act, Section 170A, speaks about intermediaries.
Yes.
I'm not sure if, in this case, given the fact that this was a 13-year-old, was there no need to assess whether this child was suitable to testify? And if he or she was, then to testify through an intermediary? Or was it taken as a matter of course that he or she can just testify? In other words, what I'm asking you is, if you were to be confronted with a child witness, are you aware of the provisions of the intermediary and the facilities that can assist under these circumstances?
I am familiar. I wouldn't say I can recite it, but I do recall that in the case of child witnesses, intermediaries should be made available.
No,
and as far as I'm aware, they are.
No, actually, in fairness to you, it's not should and it's not must. There are circumstances where they should be considered. What I'm trying to get to you, from you is, one, are you aware of that? And isn't it one of the things that perhaps maybe in your judgment could have criticized the trial court for?
I don't recall. As far as the intermediary is concerned, that's not dealt with in the
No, it's not dealt with
No,
in the
yes.
appeal at all.
Yes, perhaps because the criticism was primarily on whether or not the child was properly admonished.
Yeah, but when looking at the case in totality, the issue of how the child gives evidence is critical. Because when you look at and you state that in your judgment, where the trial court questioned the child, do you know the difference between right and wrong? What is the color of what you are? That assessment is there. And there's a specific question that is asked there as to, if I were to say this to you, would you say that I'm wrong? And you can say that the child just answered, differing from authority. So I'm just asking, if you were to be confronted with a child witness, would you consider an issue as to how the child should give evidence and the provisions of Section 170A, because they are there?
If I were hearing the trial and there is a child witness, or if
Yes.
yes, I think I would probably apply as many of the provisions that would protect the child giving evidence as possible.
Thank you very much, DCJ.
Thank you, Prof.
Can I just have a quick follow-up on that?
Yes.
No, I mean, this is something I've noticed on this issue. I mean, going back then to page 29, paragraph 10, well, this issue about admonishing the child witness, was the child witness a competent witness? And there's reference to section 163 and 164 of the Criminal Procedure Act, which is admittedly what the appellant had argued. But 163 and 164, 163 is about affirmation in lieu of an oath. It's not about trying to assess a child as to whether they can understand the truth or not. And 64 is when unsworn or unaffirmed evidence is admissible. So those sections don't appear to be quite relevant. I don't know if it was a mistake from the appellant in terms of the arguments that they put forward, but it's not about, as far as I can see, the section of the record that you quote here. It's about 163, affirmation in lieu of oath. There's nothing about children that I can see there. Did the witness take the oath? And if they didn't, did they affirm that they were going to tell the truth? I don't know if there was evidence that they took the oath or they didn't and therefore were affirmed, but I would have thought they would have taken the oath.
I think over the page is what occurred at the trial. I don't know whether that is in response, but...
Well, I'm saying what's over the page on page 30 is not relevant to those two sections of the Criminal Procedure Act.
Actually, I'm not able to respond to that.
No.
At that stage, I believe that section 163 and 164 were the relevant sections. It was a matter that was discussed with the other judge. I can't take that much further.
No,
Sorry,
can I
Commissioner.
I'm sorry,
follow
I
up?
didn't hear the last part of your response. What did you say about the other judge?
Well, yes, it was the appeal matter was discussed with the other judge. So I'm not sure, and not that I'm saying that there was anything incorrect about it, but my understanding was that that was the relevant section. I can't offhand say what that section is and whether it was relevant. My understanding is that it was.
Can I? No, Advocate Smart, I have difficulty with that because even though if your answer is, look, I cannot understand what happened at the time, that I can accept. But surely, because now it paints or it provides justification to the rumor that sometimes judges do not read the law. They just take what is in the head of argument and just put them in the judgment. That creates that impression, right? Because if a provision, the parties have referred to a provision, the first thing is to read the provision. And if somebody is arguing on the provision, is to try to get a copy of what is actually being argued, so that you can be able to determine for yourself that that provision is relevant or not. What would you say to that?
Commissioner, I do certainly ensure that I read the law before I do write the judgment. So I can't explain. I mean, it is something I do. I don't go straight out of the heads of argument and accept what is or is not there. It is something that I do research. So I don't know whether how to respond to that criticism.
No, thank you, DCJ.
Could I just follow up, DCJ? No, you see, Advocate Swart, sometimes an interview is a highly pressured sport. So have you actually confirmed that your judgment incorrectly cited the sections, or are you just going along because that's what is being put to you?
I have something that I looked at when I included the judgment. I included judgments that I had written. There weren't very many that I could include, and I didn't go over them again and check that.
I'm saying, you see, because the question of the Deputy Minister is that you've cited a wrong section. You've confused a section that is about taking an oath with a section that's about ensuring that a child witness follows what's happening. So I just want to make sure factually whether you've compared that and satisfied yourself that actually you confused the sections.
I must have confused the sections then.
No, I mean, I'm not saying you have, but have
Yeah.
you confirmed that you've confused the sections? I mean, before you admit to anything, because it's a terrible indictment to confuse sections for a judge, but I don't want to assume that you've done that unless you say, well, I've checked them, it's true that I've confused the sections.
I haven't checked them, certainly not since the judgment was written.
All right. Yes. There was something else I just wanted to put to you. I mean, which...
Is it still part of the following?
No, it's not a part of the following.
No, then you have to wait your turn, Commissioner. Had you finished? Sorry, who was it Prof? Had you finished? Okay. Pres Molemela.
Thank you very much. Good morning, Ms. Matt. Over here. Can you see me?
Right here next to me. Next to me.
Yes.
Yes.
Thank you, Commissioner.
I just want you to give me the assurance that you will cope with the workload if you are appointed. And I want to go back to the issue pertaining to the reserved judgments. And in particular, the judgment that was reserved in December 2022 and delivered only last week. Now, am I correct that your last acting stint was on the 15th, ended on the 15th of June 2023?
Yes, yes.
All right, and between 28 October 2022 and 20 February 2023, you had 2 months within which you could have started that judgment.
Yes.
And then you went back, you acted for 5 weeks, and then you had another break, almost 2 months, because it's between March and May. And still, the judgment was not forthcoming. And your acting stint ended on the 15th of June. And between 15th of June and last week, if I'm not mistaken, is another 3 months. And eventually the judgment was only delivered last week.
Yes.
Now, the reason why I'm referring to these breaks is that normally the recess periods are used by the judges to write reserved judgments. And I'm worried that you know, since the date on which the judgment was reserved, you had several breaks but still failed to produce that judgment.
Yes.
And only managed to produce it about 10 months later. Now, remember, you've had these breaks in between, and if you are appointed, you'll be having less breaks. And you'll be in court every single day, presiding over cases and so forth. And so I really need you to, assure me that notwithstanding this aspect, you would be able to cope once you are appointed. And the reason why I'm a bit concerned is that this last delayed judgment is very, very recent. In other words, one is unable to say, well, there has been an improvement ever since, because it was only delivered last week.
Commissioner, yes, the breaks in between my acting stints, as I indicated, I had to go back to practice and catch up with stuff that had built up or with new matters. As far as this most recent judgment is concerned, it was a trial which ran into about 6 days, and there were, I think, 3 Liber Arch files of documents. It was something that was preying heavily on my mind. When I did start it, I think a couple of weeks ago, it was something that I was able to finish within a couple of weeks. So I do believe that, and as I said, you know, it's a lesson, it's a hard lesson that I've learned. I will be able to cope with the pressures.
Sorry, are you saying you only started writing it a few weeks ago?
A couple of weeks ago, yes. So once I'd started it, I'd excluded everything else from my life, and I was able to finish it.
All right, now, in these 2 periods, 20 February to 24 March and 15 May to 15 June, didn't you pick up any reserved judgments during those acting periods?
There was only that one, in February, there was that one reserved judgment.
And that one you wrote and handed it down before this one?
Yes, yes.
Why were you not in a position to prioritize this one since it was an older judgment?
I think because the unlawful arrest matter was less complex and less complicated than the other matter with the trial.
Thank you, Ms. Smart. Thank you, DCJ.
DCJ, can I just confirm something? Isn't it so that the last one, the Nene one, you probably prioritized it because I had written to you and I told you that the parties were requesting a judgment?
Yes. Well, I had been working on the judgment throughout.
Yeah.
Judge President, yes.
Thank you, DCJ.
Sorry, JB, did you say the parties wrote to ask?
Yes, they read
when the
wrote,
judgment would be delivered?
Yes, and then that's when it was delivered.
All right, thank you.
Judge President, if I might just confirm that the judgment had been sent for to be handed down, I think the day before, a few days before the email was sent to your registrar. So it did cross over. Yes, thank you. But I concede that there were requests.
Just one tiny aspect arising from your engagement with President Molemela. Did I hear you correctly to say that at the end of your acting stint, you still had a reserved judgment outstanding, and then you went back to practice and did not get time to write that judgment and deliver it because you had to catch up with your work in practice? Is that what you said?
Yes, yes.
So you put the judgment aside and took on new briefs and carried on with your work?
Yes.
Okay.
The reality of practice is bills have
we
to
know
be
the
paid.
reality of practice. I have your answer. Thanks, Ms. Mata.
Thank you.
Okay. JP Mlambo.
Thank you very much, TCJ. The question I want to pursue with you, Advocate Smart, is the issue about you. I think you've explained it, whether you refuse to take on a new criminal trial or not. You remember that part?
Yes, yes.
I'm raising it from a heads of course point of view that it is usually problematic for judges and acting judges when they are allocated matters to refuse to take them simply because they don't want to accumulate part-head matters, because that has an effect on access to justice overall. Do you agree with me?
Yes, you know, in order to allocate a part-heard trial, when one is acting, it can only be allocated during recess periods. I do recall that the following recess period, when I had queried what the availability was for that next recess period, I think there were about 5 or 6 part-heard criminal trials which had been set down for that first week.
But you agree with me that it doesn't augur well for access to justice for judicial officers to refuse to take allocations simply because they don't want to accumulate part-heads?
That's not a good reason, no, absolutely. It was, as far as I'm aware, well, I do know for a fact that I haven't turned any other matters, you know, any matters that have been allocated to me, I have dealt with. It was only during that criminal stint that it might well have been because it was my first criminal stint and I wasn't that comfortable with criminal trials and I didn't know how I was going to be able to deal with them properly. I was probably a bit overwhelmed.
Okay. Thank you very much, DCJ.
Thank you, Commissioner.
Commissioner Kane?
Thank you, DCJ. Good morning, Ms. Swart.
Morning. Smart.
Smart.
Yes, thank you.
Thank you. Ms. Smart, I want to give you the opportunity to correct or improve upon an impression that arises from your application. And the impression is this, that you've had many years at the bar, you haven't applied for or taken silk as far as I understand. Your contribution to the bar and bar life seems to be pretty minimal. And the most significant matter that you list occurred some 8 Smith matter in which you were led by senior counsel. So it leaves the impression that you haven't actually got a thriving practice or done all that much at the bar. And therefore there's this question mark about what meaningful contribution you would add to the bench. Why is it that the most significant matter occurred some 18 years ago when you were led? What have you done since then that would persuade us that this impression I'm putting to you is not correct?
Commissioner Kane, the reason I mentioned the GSK matter is purely because my application was, I only came to realize that the closing date was on the 19th of June. I discovered that on the Saturday before that. So my application, I don't know how I missed that. It didn't seem that there were any notifications that came through on my email in any event. So my application was done in some haste. I could have had perhaps numerous other matters that I would have set down, but when I was going through the GlaxoSmithKline matter, it just suddenly occurred to me that that was one of the matters that I did thoroughly enjoy getting involved in. And also because it was a competition law matter, and I, you know, in KZN there are very few of those. There are matters that are of significance in the sense that, you know, various insolvency matters, other types of matters. I haven't applied for silk. My practice is such that I couldn't apply for, you know, it wouldn't have worked for me to apply for silk. Most of my briefing attorneys are small firms. I seldom used to get briefs, or I seldom get briefs from the so-called Big Five. So it's not, you know, I would have had to put if I applied for silk and was granted it, there was a real danger that my practice could have died.
Thanks, DCJ.
Thank you, Commissioner. Commissioner Jesse?
Thank you, DCJ. Good morning, Judge.
Morning, Commissioner.
Oh, advocate, sorry. In fact, I have two questions. One is a follow-up from the Judge President on criminal law. I want to ask you about sentencing. What is the discretion of the court, sentencing court, in circumstances where the sentence to be imposed is prescribed by legislation? That is
the minimum sentence.
Yes. What is the discretion of the sentencing court, if any?
If there are exceptional, substantial and exceptional circumstances which would allow the court to deviate from the minimum sentence, and those exceptional circumstances are not circumstances which are frivolous or relating to usual kind of circumstances. They have to be truly exceptional.
Yeah. But what should be the starting point of the sentencing court? How the sentencing court should approach the matter in respect of minimum sentences?
Well, it depends on what evidence is led by the accused on sentencing.
Okay. Second and the last question. We are sitting in a trial, and it arises, you found that probabilities are evenly balanced in the sense that both witnesses, main witnesses for either side are equally credible or incredible. How you should determine the matter?
That's the Stellenbosch Farmers Winery case. You would then look at the probabilities of each version and look at the credibility of the witnesses, if they both have the same type of credibility, the demeanor of the witnesses. But when all of those are equal, it would be the probabilities of either version.
No, what I'm saying in this case, you have already passed that stage. You found that probabilities are the probabilities are evenly balanced in the sense that the plaintiff's version is credible, the defendant's version is credible. They are evenly balanced. Now, how the onus in that case would have been discharged?
That would depend on the plaintiff having the onus to prove. So, yes, sorry, I might have misunderstood your question. Is that what you were asking? So it's the onus would be on the, if the onus is on the plaintiff on that point, then the plaintiff wouldn't have discharged that onus.
Commissioner Nyambi?
Thank you, DCJ. Morning, Advocate Smart.
Morning, Commissioner.
The President Molemela covered the issue of the reserve judgment, so I'm not going to ask that question. There's one issue that JP asked you about, the referral the case that was referred to you that you refused to take. And JP Mlambo also asked you and you confirm what is expected of you. But I want to afford you an opportunity now sitting here in this commission in reflecting about that conduct. What is your position now?
Yeah, it was probably inexcusable. I think I was overwhelmed. I did discuss it with one of the other judges. I initially was going to, in that last week, take on the matter. And then when, I realized that the next available date would probably be much longer than if it goes back to the usual role. And I was led to believe by the DPP's office that that matter would probably commence in any event in November, as I recall. So it might well have been completed, as Commissioner Mlambo says, quicker if it had gone back to court for a new court to hear it.
My last one, if you consider what we have said to President Molemela about the delay judgment and that conduct, don't you think that advice of JP Mlambo in attending the aspirant women judges will go a long way to assist you so that we can be able to improve on that aspect?
I have attended that seminar. I enjoyed it very much, and I hope that I did receive quite a lot from that course.
Thanks, Advocate Smart. Thank you, DCJ.
Thank you, Commissioner.
Yeah, thank you, DCJ. Just one very quick question, Advocate. The environment and in particular the issue of climate change are topical issues, now. I see that you've done a postgraduate diploma in environmental law in 2003. Have you ever had to use any of this knowledge that you gained about the environment in a matter where you represented somebody or when you sat in court? Thanks.
Commissioner Singh, I don't know if you'll recall, but I think it was about that time, I was instructed by the state attorney. You were MEC for the environment at that stage, and the issue was relating to the casino licenses, and that was one of the times that I was involved in environmental law, in an environmental law matter. And another matter was also an instruction by the state attorney relating to the oil pipeline, also for the state attorney. But yes, so it unfortunately, unless you seem to be, I haven't received any further formal instructions in terms of that area, but I've been involved certainly on a kind of pro bono basis for various organizations in assisting in advising those in those matters.
Thank you very much. I had a vague recollection that you were engaged at that time in 2003. No, thank you very much. Thank you, DCJ.
Thank you, Commissioner Singh.
Commissioner Bernard?
Thank you, DJ. Good afternoon, Advocate Mott.
Good afternoon.
Usually the procedural components of orders dealt with, towards the beginning of the order. For example, Rule 612, why the usual rules of procedure aren't useful for an urgent application and so on. So I was wondering on page 62 in the Not versus RZT matter, it's paginated page 62 of the bundle. You seem to first deal with, let's call it part of the substantial matter that's before the court, and then only towards paragraph 6, which is almost the end of the order, you then grant condemnation for the late filing of an affidavit. So I was just wondering about the logical sequence of that order, whether that is, is that something you maybe want to comment?
Commissioner Barnard, that whole issue of condemnation was dealt with at the beginning of the judgment. So there were various applications for condemnation for late filing and etc. So right at the beginning of the argument, in fact, I asked from counsel whether we could just accept that condemnation be granted and that I would deal with the costs issue at the end of the judgment, and that is why the condemnation appears at the end of that order. It was part of the orders in respect of that.
Thank you. Thank you. Okay.
Commissioner Ngugaito?
Thank you, Deputy Chief Justice. Advocate Smart, I want to come back to that discussion you had with Professor Maruma Wahaya and the Deputy Minister. The judgment itself from the bundle it starts at 28. But I just don't want to leave this under the impression that you've admitted that you confused the sections. The paragraph itself is at page 29, at paragraph 10. Do you have it?
At page 10.
Paragraph 10, page 29.
Yes. Sorry, that's line, sorry, is it line 10?
Yeah, paragraph
yes.
10.
Yes.
Yes.
Okay, yes, sorry.
You see what it says here? What you are doing there, you are not making a judgment, you are recording the submission by the appellant.
Yes.
And that's where, anyway, let me not lead you, but
Yes.
can you see what I'm trying to say?
Thank you, Commissioner. Yes, it does. The appellant contends that the court Arquoa failed to apply the provisions of 163 and 164.
Yes, and then it continues.
Whether or not there was a proper differentiation between truth and falsehood.
Yes, so do you want to reconsider your response to the Deputy Minister?
If it would make a difference, yes, please, if I may. So it was the appellant's argument that section 163 and 164 were not applied. And then in this judgment...
Well, I mean, it was the appellant's argument. It
Yes.
seems to me that those sections related to the alleged failure of the presiding officer. Oh.
Let's just give it to oh,
Thank you.
Thank you.
Yes, thank you. The judge confused the sections and applied the wrong sections because the judge did not understand that section 163 and 164 are not applicable in an instance of the competency of a child witness. And here it seems that what you were simply doing is to record what the appellant was said.
Yes.
And if the appellant got the law wrong, that's not the fault of the judge.
Yes, thank you. Thank you, Commissioner.
Yeah, and then, but there is a bigger problem with the judgment, which has been pointed out by Professor Marumoahai, that structurally the judgment doesn't draw that distinction between the competency and the knowledge of truth and falsity. But that's not because you've misinterpreted or, in fact, misquoted a section. It simply seems that the judgment itself never articulates its own premise about, is this a judgment that criticizes the magistrate because the magistrate did not properly apply the law in relation to competency, or is it because the magistrate did not apply the law in relation to the ability of the witness to know the truth and falsity? So an adult witness does not have to be assessed through competency, but a child witness does. But both of them must speak the truth. And that's what seems to be unclear from the judgment.
Commissioner, paragraphs 12 and 13 of the judgment on the following page, page 31.
Yes.
Certainly paragraph 13. The comment is that it is apparent that the presiding officer failed to make the required determination. I don't know whether that is sufficient response to the concern.
Yes, the problem is I've seen that, in fact, it's the two paragraphs, 12 and 13.
Yes.
So the one is about speaking the truth, the other is about competency. The problem is the actual finding, I can't work out what facts were relied upon to come to that conclusion. But I mean, that's within the ballpark of a judge being wrong. It's not a howler than like citing section 162 and 163, which don't apply. That's the only point I'm making there. And then the second thing, also just to clear up, to make sure that we are not left with you remember you were asked by Commissioner Kane about your contribution to bar life, and I think even there you admitted that you don't really have much contribution. But there's a letter here from the AFT. This is what it says about your contribution to bar life. So I just want you to comment on that and see maybe you are selling yourself short. What they say is that at paragraph 17 of the letter from Jigela SC, she is the convener of the pro bono committee of the KZN Bar and has also done a lot of pro bono work in her personal capacity. She has contributed to the transformation at the KZN Bar and is the only white member of AFT at the KZN Bar. AFT KZN members reported that she assists junior members and has an open door policy. She takes black junior members in on matters and she is always available to assist. She provides accommodation for junior members and permits them to use her chambers when she is away on acting appointments. So it seems actually that you've got a much more substantive contribution within the structures of the bar.
Yes,
and
thank
that
you.
You are demonstrating your commitment to transformation.
Yes, thank you, Commissioner. Perhaps what Commissioner Kane might have been referring to, and my response to her related to the formal so-called bar council. My only contribution to being involved in the formal bar council is as the pro bono subcommittee. Other than that, I've never been asked to act on the so-called formal bar council. When I joined AFT, that was when I discovered that there was a lot more that I could do in terms of getting involved, not only in meetings, but also in bar life as such.
Thank you, Decision.
Thank you, Commissioner Nkoito. At the risk of coming across as pedantic, following up on one of the aspects raised with you by Commissioner Nkoito about the reference to sections 163 and 164 of the Criminal Procedure Act, I am still not persuaded that the lifeline he threw at you saves you, actually, because nowhere in your judgment do you point out that the reference to those provisions is erroneous, and you don't say anything about them at all. And one gets the distinct impression that you never went to look at them. The usual thing is that you would have said something about them.
Chair, just clarity which Commissioner Nkoito may have missed. I didn't say, I actually said when I read out the section, I assume this is what the appellant was arguing. But the issue still is the chair says is if I say in terms of section 163 and 164 that this wasn't done properly, I would have thought a response should have been for the judge to say that's not what 163 and 64 say. Arguing point.
Yeah.
Yeah.
You don't have to respond if you don't wish.
Well, I'm not sure really how to respond further than that. It's
No, that's fine.
something that's in the judgment, that isn't in the judgment, and I can't explain that.
All right, thank you. Commissioner Mwimanga?
Thank you, DCJ. Good day, Advocate Smart.
Good afternoon, Commissioner. See you.
Just one aspect from my side in relation to page 14 of book 2 of 2, 6.2. The proportion of your litigation work in relation to constitutional law, you have indicated 0, which in essence says there is 0 exposure to constitutional law matters.
Well, I've never been instructed directly in a constitutional law matter, but where, you know, I have an awareness of constitutional principles, obviously. And since I completed this form, I've been involved in a customary law marriage situation where the Constitution and the issue of Ubuntu is certainly going to loom large. So, but as far as direct briefs for constitutional matters to the Constitutional Court, I've not been involved that I recall. It hasn't been part of my practice.
But your grasp of transformative jurisprudence is fairly good.
It has, yes, it has become. I have quite a strong interest in reading, and the issue of Ubuntu and how, certainly in the last few weeks, I've found it quite enlightening.
Thank you, Advocate Smart. Thank you, DCJ.
Commissioner Matolo-Sheku.
Thank you, Deputy Chief Justice. Mine, Advocate Smart, it's you. When Commissioner Kane asked you about why didn't you take silk, you said that taking silk would have killed your practice. And for me, it worried me in the sense that it seems that you are not getting enough briefs. I wanted to find out what is your type of practice under general, because you seem to be doing pro bono.
Yes, as I said, my clients, well, the instructions I usually get are from small firms. There are very few applicants at our bar, female applicants for silk, and those who are successful in their silk practice, other than the Annandales, etc., are those who do work for the state attorney. I haven't received, since my environmental law experience, I have not received any instructions from the state attorney, and I understand that is where most women's silks are able to maintain their silk practice, and I'm speaking generally.
Just a follow-up, have you ever raised it with the state attorney about instructions?
Every now and then circulars sent out requesting the members to advise what type of work they have been getting from the state attorney, and each time I send the same response back, and I still haven't received any instructions. So, I mean, that's just something that has been quite literally since the early 2000s, when that was the only matters I did receive from the state attorney.
Okay, thank you. I will have gone further, but thank you.
Thank you, Commissioner Matolo-Sheku. We have reached the end of your interview, Ms. Smart. Thank you very much for making yourself available for the post. Unless you have anything to say to us, you're free to go.
Thank you. Thank you very much, Commissioners.
Good day.
Good day, DCJ.
How are you?
I'm fine.
Good. Well, I'm fine too.
Yes.
Even if you didn't ask. You were a waiter at Wimpy for 10 years.
Yes, DCJ, but before that, due to poverty, just like many of us, at the age of 12, I had to go and seek for employment, and I was employed at the age of 12 as a gardener, and I worked up until I finished matric, and thereafter I started working at Wimpy as a waiter.
Mm-hmm. You were attending school whilst working as a gardener, I hope?
I was.
Okay.
During the week, over the weekends, I will go to, with the permission from the school, because at that time, it was pre-1994. Permission, a letter from the school was required, and whenever you are approached by the agencies, you were supposed to produce that letter to show that you are there.
It was a school pass.
A school pass, yes.
Yeah, I know about. I had one too. I was older, 3 years older than you when I started working, but I loved my job. I worked at an Edgar's store, handing out flyers and sweeping floors and baking tea, and I had that school pass.
Yes, thank you.
So how did you find that experience? I hope you were treated well.
I've tried to locate my employer as a gardener. He was, his name is Michael.
Mm-hmm.
I even go to the deeds office because that house is no longer owned by him. The reason why I wanted to see him, if he's still alive, was because on my first day, he made me dig a big hole just to plant just a small seed. And thereafter, he said to me, this seed will become a tree, and when it is big, it will give shade to other people at the time of need. So I want you to be that kind of a person in future.
Wow. So have you been back to the house to look at your tree?
Yes, I even, whenever I'm going past that house, sometimes it's intentionally so that I can see it. Whenever I'm going with my kids, I will always go to that house, but unfortunately it is owned by another family now.
Wow.
So I'm unable to get access to it.
So that experience actually built your character, if you listened to Mr. Michael, that is?
Yes, yes.
All right.
Yes, as a waiter, yes, it was nice because the only thing that was required from you is to have a smile on your face as I'm still having that smile.
All right. So while you were working at Wimpy, you studied, if one tallies the times when you obtained your legal qualifications, and
Yes, that is correct, DCJ. From 1996, I started to enroll for my PPROC.
All right.
Yes.
And then went on to do your LLB and a postgrad diploma thereafter.
Yes.
Did you pay your way through university?
Sorry,
Did you pay for your own fees at university?
No, it was through It was TEPSA at that stage.
Oh.
Now it's NFAS,
All
NSFAS.
right.
Yes.
Okay. So once you got your legal qualifications, you became a legal advisor with Legal Wise.
Yes, DCJ, and I believe that it was through the court's intervention, because if you look at my CV, I started at Legal Wise on the 4th of October 2000.
2000 until
Yes.
2001.
And
a little over a year.
yes, it was a permanent employment, and my father was bedridden. He was very sick, and my mother had passed away 10 months before my dad. And my father was unemployed at that time due to his sickness. And the reason why I say that it was God intervention, it's because that when I started on the 4th at Legal Wise, 10 days later, my father passed away, and my payday was going to be the 25th, and he was buried on the 21st of October. In short, DCJ, I approached the funeral parlor with the letter confirmation letter from Legal Wise to say that I will be able to pay for the funeral expenses. And on that strength of that letter from Legal Wise, and my father received a decent funeral service. And if you look at my CV, I did not stay long.
Yes, you didn't.
At Legal Wise, because 2 months later, I received a call from Legal Aid, South Africa. So that is why that it was God's intervention. That is what I believe, in order for me to bury my father.
Your father,
Yes.
yeah. Life is a way of working itself out, you know. So you did your articles and became an attorney within Legal Aid.
Yes, DCJ.
And you even became a unit manager there. You did well for yourself.
High Court unit manager.
Yeah.
Yes.
And then you took a leap and started your own law firm.
Yes, DCJ.
In 2017.
In fact, I tendered my resignation at Legal Aid in December. Then on January, the 5th of January 2017, I opened my own law firm.
You felt strong enough to stand on your own 2 feet now?
Yes.
All right. So you ran this firm until 2020?
Yes.
And then became a magistrate?
So in 2018, the firm was incorporated, and I involved 2 directors, that is Stirman and Makubane. Yes.
All right. Then you decided to join the bench and became a magistrate?
Yes, DCJ.
And you are now in acting, are you still acting in the senior magistrate's
Yes,
position?
DCJ.
All right. In the civil and family law court?
Yes.
Did you get to do any criminal work?
From 2020, I'm only dealing with civil.
What kind of work did your practice conduct?
It's a general practice.
Practice. Yes. Okay. When did you start acting in the High Court? In 2016?
Yeah, on the 10th of October 2016.
All right. And you've had intermittent stints since until the end of last year?
Yes, on the 8th of December 2022.
All right. And your application form reflects that you sat in both civil and criminal courts?
That's correct, DCJ.
Okay. Did you get an opportunity to write judgments during your acting stints?
That's correct, DCJ.
How many? Are you able to tell us?
When I counted them, they amount to plus or minus 30.
All right. You indicate that only one was taken on appeal. Well, not on appeal. An application for leave to appeal was sought and dismissed by the SCA.
Yes, DCJ, that's correct.
So your 30 judgments stand unchallenged to date.
Fortunately.
Okay. You don't have any reserved judgments. There are no partly heard matters.
None, DCJ. If you look at the last year, the session ended on the 2nd of December. But due to the fact that I was still having a criminal trial, which was a lengthy one, I approached my DJP, who was acting as JP at that time, to extend my appointment for 1 week. Then during that week, I finalized the criminal trial.
All right.
Yes.
Is your work up to date in the magistracy now, in your day job?
Up to date.
Okay.
Yes.
You mentioned that you have a partial disability.
Yes, DCJ.
Arising from a head injury.
Yes, DCJ.
When did you sustain that injury, if I may ask?
In 1994, DCJ.
Oh, so it's an old incident?
It's an old, yes.
Does it affect, well, you've managed to acquire all these fancy legal qualifications and do all these nice things you've done so far. So I can't imagine that it affects, it impedes you in any way in the execution of your duties in the workplace.
Yes. No, it affects me to the extent that my right-hand side sometimes become weak. I'm not a medical doctor, but I'm told by the medical practitioners that there is some condition which is fixed or permanent or affecting my brain nerve system, which makes my right-hand side to be weak.
All right.
Yes, and with that, I had to be given 15 minutes per hour at university in order to write my exams. So in a 3-hour paper, I was getting 45 minutes extra. But even though I was afforded that 45 minutes extra, I could not finish my paper. But I was able to pass, and my BPROC, I was supposed to be doing it for 5 years, but I did it within 4 years, and my postgrad LLB, it was supposed to be 2 years, and I did it within 1 year.
All right. So this does not affect your cognitive abilities?
No,
All
not
right.
DCJ.
Are you able to, judges work really long hours as you would have experienced. Are you able to cope?
Yes, I am. Since from legal aid, as a legal aid practitioner working for the High Court, we used to receive thick files for criminal appeals, and one was expected to produce sets of arguments within a certain time and to be filed timelessly. And I was able to do that for all the years I practiced in the High Court.
Sorry, I'm not sure if I asked you this. What is the total period of time you acted?
When I counted, it gave me plus 35 weeks.
Okay.
Yes.
Over 30 weeks.
Over 30 weeks.
All right. One of the professional bodies says that you are not ready for permanent appointment. This is the Advocates for Transformation. And they don't support your candidature.
I've seen it, DCJ.
Do you have anything to say to that? Do you think you are ready for
Yes, I
commendable
think
work.
I'm ready. Why I'm saying this, DCJ, in as much as I acknowledge their comment and I respect their organization, but I had given them my judgments, which is a criminal appeal and judgment, a criminal trial judgment, as well as a civil judgment. But they did not comment to say where I might have made mistakes or to show that I don't have sufficient civil experience. Just like other follow bodies who commented on all my judgments.
Yeah. The GCB, for example, says your judgments appear to be well written and well reasoned.
Yes, DCJ.
Oh, well, I'll leave it to your JP to probe this further with you.
Yes.
I stop here for my own purposes and hand over to the other commissioners. JP?
Thank you, DCJ. Good morning, good afternoon, Mr. Zakwa.
Thank you, JP.
We know each other for a very long time, from the BLA days.
Yes.
I just wanted to put that up front.
Yes.
Now, perhaps just before we get to AFT, I want to focus on your application because the LSSA supports you. I think, yes, it is the Law Society of South Africa, they support you. But they bring to your attention the errors that are in your application. And you sent a response, and you say you accept that there are minor typographical and spelling errors in my questionnaire, such as the first acting period, and you carry on. But the point I want to make is they are not minor. They are a lot of errors in your application.
I accept that.
But why is that so? Because as the position that you are applying to be a judge, it's another step, another level in the profession. And this body, I'm sure, is expected to receive a very well-prepared application when it comes from candidates. I have counted only in your application and your CV about 30 errors, 30.
I accept that. It might be that at the time when I was completing this questionnaire, I was not well, but that cannot be used as an excuse. But in executing my judicial function, I don't see any errors.
Yes, but you see, the difficulty I have as a JP, you haven't acted, for instance, under my supervision.
Yes.
So I don't know much your work other than we know each other from the BLA. So I take your application and read your judgments, and that's what would probably form part of the view that I would take and that I would submit to the commission. But with these errors, how do I say that we must go past them? Look at the covering letter. The covering letter has got capital letters in the middle of a sentence. And also your name is spelled incorrectly. Did you see that? Or is it spelled like that in your ID?
In my ID.
Or that is how it's spelled? Yes. Or because I was quite concerned. But having said that, it doesn't detract from the errors that I say are in your application. And you don't seem to have taken the time to update your CV, because I will take you to the page in particular, which really concerns me. Page 23.
Yes.
So that's where you were listing the responsibilities. I assume of the responsibility, because it's not clear there as to what responsibilities were you talking about. I assume that these were the responsibilities in the law firm that you were dealing with. So for instance, in bullet 1, 2, 3, 4, 5, about 9 or 10 petition papers to the judge president of this division, as well as the Chief Justice of the Supreme Court of Appeal. So for me, you have not updated your CV properly, because you would not have that, that heading for the Supreme Court of Appeal.
That's correct.
What is the head of that court? How do you say it is?
The president.
Yes.
DCJ.
So it would not be the Chief Justice of the
Yes,
Supreme.
yes.
Yes. So those are some of the minor things that it's not minor for me. You say they are minor, but for me they are not minor, because the positions that we are filling as a division are for experienced judges that have retired. So we need a lot of experience, a lot of expertise, a lot of people that apply their minds when they do their work. So let's then leave from the errors in the application. Your strength seems to be the criminal background.
Yes, that's correct.
And I see that you have acted twice only for civil.
Yes, that's correct.
Yes. And I think one of the reasons why AFT says they don't know you is, even when I checked with the other judges whether you had acted in Durban, most of them said no, because they couldn't remember. But I only saw in your application that you say you acted in October 2018.
Yes, JP.
Yes.
You were there.
Yes.
It was at the time of one of the senior judges was not well, and I had to be roped in to fill that position for that senior judge.
Yes. Yeah, but the point I'm making is some time ago, more than 5 years ago. So you haven't been there recently. But then coming back to civil, don't you believe that you would benefit from more acting appointments and you concentrate more on civil?
I am of that view, JP, but with my position right now at the magistrate court, although the complexity of the matters, they are not the same, but I deal with a lot of civil matters.
Yes. Why I'm suggesting that, if you look at page 93 of your bundle, that is the matter that is your civil judgment.
Yes.
That you dealt with. But perhaps before I get into my question, if you look at page 105, you've put that order in, that is in my name, unfortunately. But what was the purpose for that page to be put there?
So it was mainly because I had ordered that the respondent company should be provisionally liquidated, and the return date was on the 25th of May, 2023. And on that day, when going back to the High Court to check what happened, and I could see that the matter was dealt with and finalized.
But I don't understand the importance of you putting that page in your application.
It was only that, Judge President.
Because I don't know whether you would have thought that they would appeal or your order was confirmed. So I was not sure as to what the purpose of putting that was.
When I went to the High Court to check on all of my matters, if they were appealed or not, I only find that there's only one matter which was taken on appeal. And this one, the civil judgment, was finalized and nothing more to show that it was taken on appeal or not.
But at that stage, you had granted a provisional order.
Yes, yes, Your Worship.
Would they have appealed it at that stage?
No.
Yes. So that's why I was confused as to. So let's look at that order that you granted. So how long did that judgment take you? Because it's not clear there as to when had you reserved it and when was it handed down? It was handed down on the 18th of November 2022, but it doesn't show when had you reserved it.
Yes, it took me within 5 days, JP, because if you read that my judgment, it was argued, although it was argued by applicant only because the respondent counsel received instruction to terminate the mandate. And yes, it was within a week.
But that concerns me further because if you delivered your judgment on the 18th of November and then you give a return date as May 2023, why such a long period?
JP, I can only say that it was because the parties have approached me in chamber and especially the applicants, because they were also concerned that the employees of the respondent, they were not notified, and the order had to include an order that these this order should be served on the employees in terms of in compliance with Section 197B of the Labour Relations Act. That was according to the applicant's counsel.
But that concerns me because the application, isn't the application ought to have been served on the company and the notice ought to have been placed on a notice board somewhere so that the employees could see? So if they told you this at the time of hearing the matter, that the employees were not aware, how then did you continue to deal with the matter?
I continued to deal with the matter because there was no application for postponement, 1. 2, the respondent papers also did not challenge that position that the employees were not served. In fact, the heads of arguments of the counsel who was appearing on behalf of the respondent make reference that that could be cured by sending the order to inform or disclose to the employees in compliance with Section 197 of Labour Relations Act.
Well, I think I'll leave that point there. Let's just go to the order. The order that you granted in page 93 and page 104, you say, I accordingly proposed the granting of the following orders. Why must you propose to grant the order and not grant the order? Was that an order in the first place, if it's couched like that?
Yes, it was an order, but the word proposed, I will not take that any further.
That it concerns me because such orders you grant on appeals when you're sitting with another judge, and that other judge will then agree and order and would say, it is so ordered, so that it doesn't become just a proposal. So when you leave it like that, it's then a proposal in my view.
I understand.
Yes.
Judge President.
Now, in that judgment, it was very difficult for me to follow the judgment itself. And because you seem to have, I don't know whether there was even an application for a postponement, but there was somebody who had appeared for the respondents, and I don't know what happened, because if you look at paragraph 14, there are various things that arise which I wasn't sure of. I was not sure whether the respondents knew that the matter was set down in the first place. Because if you read that Ms. Perumal, there was somewhere where it says the matter was not on the roll. In paragraph 15, it says an SMS message from a cell phone, and this is the evidence you accepted, by the way, from the bar. An SMS message from cell phone, which is from those attorneys, was read by applicant's counsel, confirming that the counsel instructed by Keith was in court this morning and left as he thought the matter was not on the roll. But Keith Joseph seemed to abide by the court's decision, they stated in the SMS. So I wasn't sure whether, if there was another advocate there for the matter, and then they believed that the matter was on the roll, what was the final? As I say, it's not clear from your judgment as I read it.
If you look at paragraph 14, down to the beginning of paragraph 15, it shows clearly that Ms. Perumal was on record and the notice of set down had been sent to their offices, and at that stage, Ms. Perumal was an attorney of record. And on 26 October 2022, that is where the twist came, when Ms. Perumal received a letter coming from Keith, from other attorneys to say that they have been instructed in this matter, but they were not going to ask for postponement on the day of hearing.
I think it's a complicated issue because it seems to me that Ms. Perumal's mandate was terminated, and then there was this other advocate who had been appointed to act, who thought the matter was not on the roll. So it's quite a lot of issues. But then in your judgment, you also base most of the findings, or when you evaluate, on what Ms. Perumal had filed as the heads of argument. So it's, as I say, it was very confusing. But I think I'll move on from there and just say this. In talking to some of the colleagues about your application, some raised some concern that when you were acting, particularly in Pietermaritzburg, you had lots of visitors in your chambers. And these were the people from outside. Is that a fair observation. Because as you would know, the judge's space is very guided. And so they were concerned with a lot of traffic, so to say.
I wouldn't comment much to that, but all what I know is that because I've been practicing in that court, in Pietermaritzburg High Court, most of the clerks or registrars and ushers, they would now and again come whenever, say, to greet or what. But I will tell the secretary not to allow them.
Yes.
But I cannot say that I had a lot of visitors from outside.
Yes. Perhaps just one or two things then generally on the civil law. I just want to check at what stage do the litigants bring an application for summary judgment?
When the summons have been served to the defendant and the defendant has filed a notice of intention to defend and thereafter filed the defendant's plea, and the applicant, the plaintiff, may file or bring an application for summary judgment on the basis that they believe that the defendant is only filing the plea malified, they don't have bona fide defense.
Yes.
Yes.
And the term usual order in summary judgment applications, what does it generally refer to? If one says the usual order was granted?
It means that I can't answer that.
Yes. All right. Lastly, the reviews, one can bring the reviews in terms of PAJA or as a legality review. Are there timeframes that are applicable in bringing these reviews?
Yeah. Yes, Section 7(1) of PAJA provides that such applications can be brought within the period of 180 days. That is 6 months.
Yes, and the legality review?
Not PAJA.
Yes.
Yes. I think it is not regulated in terms of PAJA. The review application can be brought within a reasonable period after the decision was made.
Yes, thank you. Thank you, DCJ.
Thank you, JP. Premier, do you have questions for this candidate?
Thank you very much, DCJ. Good afternoon, Mr. Zak. My one is just on the from the LSSA about the fact that the typographical and spelling errors, particularly in relation to the fact that it's the form that was being filled by Mr. Zaka that has got that questionnaire that has got so much spelling and typographical errors. I'm just trying to really find out, is this normal that you would have such errors, Mr. Zaka?
Yes, thank you, Premier. No, it's not normal. As I'm saying that maybe it was attributed by the fact that at the time of completion of this questionnaire, I was not well, but that cannot be used as an excuse. But normally, I don't have such typographical errors.
Do you have more questions, Premier?
Just the last one, TCJ. Just to understand, will this perhaps be an indication that you might still be needing more exposure and experience in this regard?
It may be, I will, if this commission decide otherwise, I will accept the invitation to have more acting stints, but that is not normally what is happening, that I have a lot of typographical errors.
Thank you, TCJ.
Thank you, Premier. Just to follow up on this issue of typos, Mr. Zak, when the JP asked you about this, I did not hear you, express any contrition for your sloppiness, because your papers, your application papers are just sloppy, including some of your judgments, by the way. One picks up a number of typos there. One judgment being the insolvency one, which in which you proposed in granting an order. You repeated that erroneous statement twice, but then I'm prepared to grant you pardon, because I know how hectic things can be in the High Court, and if you don't ask somebody else to proofread your work, it is very easy. We all make this kind of mistakes. That's why you need to be careful and always ask to have another pair of eyes looking at your work before you send it out. So I'm willing to forgive you for the typos, but your attitude does not show that you understand that being meticulous is one of the hallmarks of a good judge. You cannot be a sloppy judge. The two words don't go together. Do you get that?
Yes.
So you do recognize that you could have done better.
Yes,
you
I
should
do.
not have sent the JSC papers that are riddled with these careless mistakes.
Yes, I do appreciate DCJ.
Applying for a high judicial office.
Yes, DCJ.
Okay, thank you. Professor, DM?
Good afternoon, Mr. Zatla. No, I don't have any questions, DCJ.
Okay, thank you. Prof?
Thank you very much, DCJ. Good afternoon.
Yes, good afternoon, Commissioner.
I just want to, mine is a very short one. I just want to take you to the case that you have just conversed with the JP, the one that deals with liquidation and National Credit Act and all those issues. I'm not sure, do you have it?
Yes,
paragraph 30 of that decision. Well, it is commendable that you were able to produce such a judgment in 5 days, I must say, because this is one of the most difficult areas of our law, interaction between company law, national credit law, and insolvency law. But I mean, you deal with, I think the parties pleaded factual and commercial insolvency. Yes, and or in the alternative, that if they don't get one, they might as well get another one, and you dealt with that. Yes. But there is something that really I was not sure what you actually meant in paragraph 30, where you say, in 1, 2, 3, 4, 5, 6, 7, 8, in like the 8th line from the top, or perhaps maybe let me start where the sentence actually starts. Well, in light of the above circumstances, and more particularly respondents' failure to pay its contractual debts, which prima facie exist, including failure to make partial payment, I find that the respondent is factually and legally unable to pay its debts. I'm just concerned about this legally. What does it mean that somebody is legally unable to pay debts? That's what kind of like confused me as to what you were explaining. What does it mean that somebody is legally? I mean, if you cannot pay, you cannot pay. How does it become legally? How do you become legally unable to pay? I'm not saying you are wrong. I just want you to enlighten me.
Yes, thank you, Commissioner. My reasoning there was that due to the fact that the respondent had failed, firstly, there was a default judgment which had been granted against the respondent, of which that default judgment was not rescinded. So legally, they were unable to pay.
That's the part that I don't understand. Yes. Because if I owe you, and I'm not saying you are wrong, I just want to understand for my benefit, perhaps maybe for my students who are watching. If you owe me and you are unable to pay me, I think that is as a matter of fact, you are unable to pay me. So you cannot give me the money. Like practically, you cannot give me the money. I just want to understand this legally. Like, how do you legally become unable to pay somebody? Are you prevented by statute from paying, perhaps
No,
maybe, or
no,
the
no.
constitution, or like, how do you become legally unable to pay somebody?
I was not referring to that. I mean, to that ame any piece of statutes obliged the respondent to pay. But I was looking at the fact that there was a default judgment that was taken against the respondent company, which remained unrescinded. And the inability to pay was a matter of fact. And yes, the other word that I could have used was contractually bound to pay, because this large credit agreement, which was extended to the respondent, was in fact in terms of contract.
No, it's fine. Like I said, I cannot work it out in my mind as well, so you might well be right. Thank you very much, DCJ.
Any more questions for the candidate, colleagues? No. Well, we've reached the end of your interview, Mr. Zaxa. Thank you for making yourself available for this position. You're excused.
Thank you, TCJ and the commissioners.
Colleagues, are we going to deliberate and then have lunch? What do you want to do? Deliberate. Okay. Good afternoon, Mr. Lidwaba.
Good afternoon, ICJ and commissioners.
Are you well?
I'm well.
Are you comfortable?
Yes, I think I'm comfortable, yes.
All right, let's go then. You hold 4 degrees, AB Proc and LLB, and 2 master's degrees.
Yes, that's correct.
Obtained variously from University of Limpopo. Is that TEFLOP?
Yes, that's definitely.
All right. I find it misleading to refer to our old universities with these new names.
Well,
And University of Pretoria and UNISA.
yes.
Okay. What were your masters on?
There are 2 masters there. I don't know which one you're talking about. The one was on labor law, UNISA one, and the other one was on constitutional law.
The one from UP?
From the University of Pretoria, yes.
Okay.
Yeah.
You started out as a teacher?
A private teacher, yes.
But that was a very brief spell.
Yeah, 6 months. Yeah.
And you went to the magistrate's court?
Yeah.
Started out as a clerk, an ordinary clerk?
Yeah, just ordinary clerk, yeah.
Became, or in both civil and criminal courts?
Yes.
And then you became an interpreter?
Interpreter as well, yes.
Was that on promotion? How did that come about?
Well, they look at your performance and they decide that you come to a section, yes. Yeah.
And then you became a prosecutor?
Well, that was an appointed prosecutor. That's why I attached the section there, because then at that point you could just be appointed by the presiding officer, but it's not a prosecutor that has degree.
Yeah, but you were still doing the work?
Yes, I'm still doing the work, yes.
For how long did you do that?
Well, they will appoint you, you'll decide maybe today, tomorrow.
It was an ad hoc arrangement?
Ad hoc, yes.
All right.
That was happening during the time when the prosecutors were on holidays, they were writing exams. Then
All
they would
right.
just decide, yes.
Okay, then you decided to become an attorney and did your articles of clerkship?
Yes.
In 1989?
1989, yes.
And when you finished those, you joined the Lawyers for Human Rights?
Yes.
As a legal officer?
As a legal officer and placement officer as well.
All right. Yeah. How long did you remain there?
I think it was 1990, I think it was 2 years, it was 1991, 1993 somewhere. Yeah, it was a very short stint.
Yeah, but by the time you left, you were a deputy director of litigation. You must have worked very hard.
Yeah, worked very hard then, yeah.
Okay. Then you joined Moima Ledwaba Incorporated as a director.
Yeah, we actually formed that firm. We formed founder members.
Yes. In 1994?
1994, yes, yeah.
Until 2006?
Yes, 2006 when I left and then I went to the bar.
All right.
Yeah.
What kind of work did the practice do? The attorney's practice?
It's general practice, but mostly criminal.
Okay.
Yes.
So you joined the Pretoria Bar?
Yes, then I joined the Pretoria Bar.
And you also hold chambers in Polokwane?
Well, I started in Pretoria, and then Polokwane I just went there, I think 3 years back, and then when we formed another group there, and then I went to Polokwane.
All right.
When we formed G20 group.
Okay. And you've also, at the same time you joined the bar, you started working part-time as a CCMA commissioner?
Yes, at the same time, yeah.
But not any longer, I see.
Sorry?
You stopped in 2014? You left?
You left it, yes.
2014.
Yes, 2008 to 2014, I think that's what I left.
Okay. How long have you been an advocate then? Since 2008? Oh, it's been a while.
Yeah, up to now, I think, I'm not sure, 16, 17 years or so.
Yeah.
I haven't counted them, yeah.
All right. And do you have any areas of specialty, or you just run a general practice?
Yeah, well, do general, it's not specific.
Okay.
It's not specific that I'm doing, yeah.
When did you start acting as a judge?
2019.
And how long, what is the total period?
65 weeks.
65 weeks.
Yes.
And you've written judgments, of course.
Yes.
How many?
I didn't tally, I didn't count them. How many are they?
But there are more than 10.
Yeah, there are more than 10.
Okay. Have any of them been reported?
Well, I said on Safely, but I discovered that Safely is not the reported platform, so I don't think there's anyone other than the one that are listed on Safely. Yeah.
Have you been taken on appeal?
Yeah, I've been taken on appeal.
How many times?
I think 3 or 4 times, but I listed the judgments there.
Oh, I want to hear from you.
Sorry?
I want to hear from you.
From me, yeah, I think it could be 3 or 4.
And what was the result of those challenges? Were you overturned?
The SC agreed with me.
All right, that's always heartening, encouraging. You don't have any. When was your last acting stint? In December 2022, last year.
Yeah, October, December last year.
And it lasted for 8 weeks, I see.
Yes.
You don't have any reserve judgments outstanding from that stint?
No, I don't have, no.
All right. Let's see. No, I'll leave the rest of the issues I may have to JP Mlambo. Sorry. I'm sorry, JP Mlambo. I'll leave the rest of the questions to the head of the court to which you are applying, Judge Semenya. Yes, I know who you are. That's what I just said.
Good afternoon, Acting Judge President.
Sit down. Okay. You have made yourself available for Thohoyandou High Court Local Division.
Yes.
And you are aware that there is no women judge there. There are it is a seat of 3 judges, and there are no women judges.
I'm aware of that, yes.
And also, Limpopo as a whole, there are 9 judges there, but 2 of them are women.
I'm aware of that, yes.
Which means I'm including myself as well,
yes,
when I say 2 years.
Yes.
And Saji has just completed training aspirant women judges.
Yeah.
I was not one of the mentors, but some judges there at the division were mentoring 2 of them. And on the comments that they wrote to the Saji, they said with one of them, in fact, they recommended the 2 of them. But the comments were, she is not ready for acting. She's actually ready for appointment as a judge. Those are the comments that were made by the judges who were mentoring the 2 who were with us. And also, should you be appointed to this position, it means that there won't be another position where we can fit in another women judge, because you are likely to be there for about 10 years, if I'm not mistaken. I look at your age and I see that you can still work for about, until you reach 70, it will be 8 years. If you push up to 75, then it means for that period, we won't be able to appoint a women judge in the local division at Thohoyandou. Do you think that should you be appointed, we will be sending a correct message out there that you are serious about transformation?
Well, let me put it in this way. I'm here to sell my candidature on the basis of the Constitution. And the Constitution says you must be properly qualified and be fit and proper. That's why I'm here. But what the Commission does is up to them. But I'm here to sell my candidature.
Okay, thank you. You have acted there at Thohoyandou, and you did only civil work. But I take it that you are aware of what is happening at Thohoyandou. we have been named as one of the worst performing courts. And it is mainly because of the backlog that we are having with criminal matters. I was there the whole of the last term last year, and I realized that many of the cases are postponed for 30 times without even a plea. I know that you are not a party to that. It is not because of yourself that we are in this situation, but I just want to give you an idea of what is happening there, and that the type of a judge that would need to assist us with that criminal backlog. Cases are postponed, the roll collapses on Monday. Cases are postponed for 30, 40 times without the trial even starting. Witnesses are lost in between because some of them will come to court until they say they don't want to go there anymore because they go there merely for postponements. So we require a judge who will put his or her foot down to see to it that everybody is ready for trial so that trial can commence and we won't have this backlog that you are having. I see that you have indicated in your questionnaire that you are doing criminal cases. Do you believe that you will be of assistance as far as this backlog is concerned?
Absolutely, absolutely. I believe I'll be assistance, yes.
Thank you. I've got no further questions. Thank you.
Thank you, DJP. Just to follow up on portion of your engagement with the DJP. In response to her question whether your appointment would advance the transformation imperative in that division, you invoked the Constitution and said you are a fit and proper judge. I just wanted to remind you of subsection 2 of 174 of the Constitution, which enjoins the body that conducts this process to reflect, to make sure that the result is a judiciary that reflects broadly the racial and gender composition of the country. So it's not enough to be just, the JSC does not just look at whether a candidate is fit and proper. There is more that should be considered. I was just reminding, I'm sure you know this, I was just reminding you.
I'm aware of that, but that section 174, it talks about nationally. I thought she was talking at provincial level.
All right.
Yeah.
Sorry.
DCJ, can I also maybe assist this candidate to answer this question? Are you familiar with the recently published criteria by which we appoint judges?
They were sent to me, they were sent to us, but I can't remember them off heart now. But I don't know how they relate to the Constitution itself.
All right, thank you, DCJ. I'll wait my turn. I thought I was going to help, but I don't think I can. All right, yes. Clause 24 of the guidelines says that in evaluating a candidate's professional experience and potential, the JSC may take into consideration that opportunities for advancement in the profession for black persons and women were limited by institutional, historical, systemic, and other barriers. The reality of race-based and gender-based bias which hinder worthy candidates from obtaining experience and competency in certain areas of practice should not result in candidates being unfairly disqualified. And then here is the point I want to comment. It says, where a candidate who will not enhance, which is you, the racial or gender representativity is better qualified in an important respect, the JSC should give due consideration to that fact in weighing all relevant factors. This may include the overall needs of the judiciary, the performance and the needs of the relevant court, discrimination that still pervades the legal practice, and the extent to which the candidate may have been historically prejudiced. So it seems that the mere fact that you are a man is not an automatic disqualifier, but we have to take into account other features that could compensate for the fact that your appointment will block transformation. The real question is, what are those features?
Yes, okay. I agree with you. I agree with you, but in my case, I think given my track record from the time when I was an attorney and when I was acting and the judgment that I wrote, I think those will be taken into account. It should serve in my favor.
Yes. But I mean, we interview attorneys all the time. We interview people who've acted all the time. So there has to be something exceptional that would then compensate for the fact that you will be a stumbling block to transformation. So are there any of those features that in your application are compelling enough?
Well, other than to say that my experience, my participation, and my judgments, I don't think I can take it any further than that. I'll say that I'm given where I am and what I gave to you to consider me, I think it makes me to be favorable to be appointed. That's what I can take.
Thank you, Commissioner. Advocate Singh, first, before you ask the question, let me just take this opportunity to greet you and welcome you. I forgot to do that earlier.
Thanks, DCG. We greeted twice today.
Well, not in this room.
Not in this room. Thank you. Advocate Ledwaba, good afternoon, sir.
Good afternoon.
Let me assist you with what the acting JP asked and what Commissioner asked you now. The acting JP was telling you about the criminal law issues, matters in Toyando.
Yes.
In your application, I see you do mention that you got, in your spread of litigation, that you do 20% criminal work.
Yes.
And then if you go to page 19, no, sorry, what page is that? Let me just see. Page 22, page 22. Then the question is, did you sit in both civil and criminal courts? And you said yes. And then you said, give details. You said in criminal courts, I did appeals, petitions, automatic reviews, as well as criminal trials. Yes. I think the commissioner tried to elicit from you, what is it exactly it is that makes you a proper candidate for the post, bearing transformation in mind? You have to show what is it that you can bring to the fore. And the issues raised was criminal court matters. And I have another question on traditional leadership matters. So perhaps before we go to traditional leadership matters, tell us what is your expertise with criminal cases?
Well, criminal cases, that's where I started. As an interpreter, I did interpreting at that level as an interpreter. And as an attorney at that time, most of what we were doing, starting from being a candidate attorney, was criminal. So there was a gap when I was an advocate where I did not do much of criminal trials because I didn't get work there. But after that, as an acting, I did a lot of appeals criminals. And now in October last year, I was specifically put in a criminal section where I was doing criminal trials. So that's where I'll say I did most of criminal works.
Okay, thank you. And then my second question is, and I'm going to refer back to the new guidelines for the JSC. At point number 13, it says local knowledge and expertise should be valued, but it should not be a disqualifying factor if the candidate does not come from that region. I know you practice in Limpopo. With regard to traditional leadership, what is your experience not only as a practitioner, but also as an acting judge?
Yes, well, as a practitioner, I did a lot of work in respect of traditional leadership. And as a judge as well, I've never delivered a judgment that deals with traditional leadership, but I did it as an advocate. But as I said, I don't remember delivering a judgment that deals with traditional leadership, no.
Thank you, Advocate Ledwaba. Thank you, DCJ. That's all for me.
Thank you, Advocate. DM?
Good afternoon, Mr. Ledwaba, or Advocate Ledwaba. Mine question is about minimum sentences. And I want to know your view on minimum sentences set by Parliament in legislation. What is the rule? What does the law say about minimum sentences in terms of when you can deviate from them? And what do you think of minimum sentences for Parliament setting minimum sentences? And then lastly, do you think it's appropriate that a person convicted of rape of a child should not get a custodial sentence?
Okay. The minimum sentence is ordained in terms of the Act. As Section 51(1), it tells you when a person has committed a criminal offense of rape or murder under certain circumstances, must go straight to life imprisonment. And in 51(2), it talks about, set about minimum sentence in terms of ages, in terms of whether you were first offender, second offender, and stuff like that. Then 51(3), it talks about deviations, and it says you can deviate from ordained minimum sentence if there are substantial and compelling circumstances. And what I think about the rape cases, I think they fall under schedule that compels a judge, if there are not substantial compelling circumstances, to give life imprisonment.
Do you regard as substantial and compelling circumstances not to give the minimum sentence in a rape matter, rape of a child?
Well, they're not defined. I mean, the law says that it's not, whether this is substantial compelling circumstance, they're not defined. They differ from case.
What would you regard? I mean, so if it's, say, for example, the child was raped by somebody in the family, and it's not so bad because they knew the person.
No.
Would you regard that as substantial and compelling?
No, it won't be substantial compelling. No.
Okay.
No.
All right. No, thanks. I asked the question because I think there have been judgments from the Limpopo High Court regarding sentences where some strange reasons have been given for deviating. Thanks.
Thank you.
Thank you, Deputy Minister. Commissioner Nyambi.
Thanks, DCJ. Afternoon, Advocate Dwaba.
Afternoon, Commissioner.
As we are here last year, April,
Yes.
I'm affording you an opportunity now to share with the Commission something significant besides the acting stint that has happened that this time around we have to seriously consider in your favor. We have the records, we still remember what happened last time, but anything that we think we have to this time around seriously consider that were not considered then, or that must have happened in your life as Advocate Letwaba.
Is Commissioner talking about, apart from the fact that in October to December was paid specifically in criminal case?
Yeah, besides the acting stint, anything?
Anything else? Well, I'm an advocate. I've been practicing as an advocate, and I was doing a lot of work. I was doing a lot of work. As we speak now, we have cases that's come from the province that has been taken to the appeal court on traditional leadership. So I've been doing that as an ongoing, but I've been doing work as an advocate on ongoing basis. So that improved my ability to act.
I thought when you were responding to the DJP about the issue of the gender composition of that division, you said you are here to market yourself. So I was affording that opportunity, but...
Okay, all right, I missed it. Okay. At the bar, we given people every year. And ever since I joined the Limpopo Day, I've been given 3 people. 2 of them are females. So in that regard, I've contributed to the transformation as far as women are concerned.
Thanks, Advocate. Thank you, TCJ.
Thank you, Commissioner Nyambi. Are there any further questions for this candidate, colleagues? JP Mlambo.
Thank you very much, DCJ. Good afternoon, Advocate Ludwaba.
Good afternoon, Commissioner.
I just want to say, I don't have a question for you, but just to say congratulations on the judgment you wrote in Marathon.
Oh, that one, yes. That one I should have mentioned when it say, is the end conclusion that I did, because I wrote a judgment that went to the SCA and also went to the Constitutional Court, which you penned as the judge. I was happy with what you agreed with me.
You were confirmed by both the SCA and the CC?
Yes, yes.
President Mulemelo.
Yes, good afternoon, Mr. Lidwaba.
Good afternoon, Commissioner.
I just want to canvass what has already been canvassed with you in relation to the demographics and the composition of the bench in Limpopo, the provisions of the JSC criteria, and the provisions of the Constitution. That in light of all of that and the information that the composition of that bench at the moment does not match the demographics, and that if this position is filled at this stage, there'll be a long time before another vacancy arises. Would you feel terribly discriminated against if the position was not to be filled at this stage, to enable a next round of interviews where perhaps competent women could be appointed in that position?
But maybe let me put it this way. That division has got two courts. It's got the Toando and the Polokwane. There's still a position in Polokwane where a woman can be placed there. And my understanding is that the JP there can take a judge from one division, from one town to another. Yes, I'll feel aggrieved if I've met qualifications, if I've met criteria, if in terms of the criteria that has been set down by the Commission itself, it comes to a point of saying, we're not going to appoint you simply because you are a man. Well, I won't feel good.
Would that not be ameliorated by the fact that perhaps the community in that area would be pleased if they were to see gender parity on the bench?
Well, as I say, there's one position that's still outstanding where a woman can be placed there. So it's not a loss. If I'm appointed now, it doesn't mean that there's not going to be another appointment for a woman. Because in Polokwane, as I say, there's still a vacant post there.
Thank you, Mr. Lidwaba. Thank you, DCJ.
Thank you.
Any further questions, commissioners, on the virtual platform? No.
I did have a question, DCJ.
Oh, go ahead.
Yes, I was trying to reserve my position. Advocate Ludwaba, I wanted to ask you about just 2 points, just to make sure that I'm clear. Are you not the advocate that there has a pending complaint before the LPC?
Yes, I'm the one. I brought that complaint to the attention of the commissioners.
Yes, and that's about duplicating invoices.
Yeah, that's their version. They say are duplicated invoices, and what they did. When we discussed that bill, we agreed that what they say is duplicated must be removed, and that was removed.
What's the status now of that complaint?
Well, where we are now, the complainant SLED is filed the complaint. I responded, and then she replied. And then when I responded, I said to the council, I say, this is a dispute about fees. My request is that, as the body, please arbitrate and tell us what is the figure, because we differ on the figures. Whatever figure you decide on, I'll accept it. And then that will be the end of the matter.
I understand. I don't want to know the details. You will answer before the LPC.
Yeah.
What is important for us is to know whether that complaint has been resolved or it is pending.
No, I left at the point where we made our submissions and they say they were going to take it to investigating committee. I haven't heard anything from them. But the last letter that they wrote to me, they said it's not going to be necessary. I think I touched on the document. It's not necessary. They're not going to call us. They will make a decision.
All right. But no, I'm still not sure. Is the complaint pending or closed?
No, I don't know what my understanding of the process is that they receive submission from the parties.
Yes.
They give it to the investigating committee.
Yes.
The committee decides whether it's a valid complaint or not.
Yes.
But as I say, my submission was that this is a few dispute because we differ on figure. Actually, I accepted their figures. It's just that then something happened and they did not accept the figure. I said, if they look at the statement of account and they find that they arrive at a figure,
Yes.
in order to get this matter to the end, I will accept the figure. And that's why I left it there.
But you're still not answering my question, I'm afraid. Is the complaint closed or is it still pending?
It's still pending.
All right.
Yes.
Look, there's no point in asking my next question, DCJ. Thank you.
All right. Thank you very much. We've reached the end of your interview, Mr. Lidwaba. Thank you for coming. You're excused.
Thank you. Thank you so much. Thanks, Commissioners.